All right, we'll go ahead and start a few seconds early. Good afternoon. Welcome, everyone, to the afternoon session. Ms. Larson, I believe you have a minor item to take care of before we start the next docket.
Yes, thank you, Mr. Chair. Yesterday, in the matter of extraction oil and gas and Larson, when I read in the docket numbers, there was one docket number in that matter that was not read into the record. So I would just like to clarify that the docket numbers that were heard and adjudicated yesterday were 1806-00426, 1806-00429, 1806-00431, 1806-00441, 1806-00449, 1806-00454, and 1810-00743.
The last one again, 007?
1810-00743.
All right. Thank you. With that, would you like to start the next item?
I would. So before you next is the matter docket number 1806-00390, Oak Creek and Noble Energy. And Hearing Officer Peskin will have an introduction on this matter for you.
Please proceed, Mr. Peskin.
Thank you, Chair Benton. This is Hearing Officer Peskin. This started off as an ordinary pooling application filed by Noble back in March of 2018. It was amended approximately a week later. There are underlying district court issues that are tied to this dispute between these parties that relate to a quiet title dispute regarding ownership of the minerals. One of the issues that I had to deal with in this case surrounded the fact that Noble filed its application prior to the issuance of that decision by the district court regarding the quiet title action. Following the quiet title action decision, there were pre-hearing conferences at which point Noble admitted on the record that it no longer disputed the validity of Oak Creek's interest to these minerals. We allowed for limited discovery. Oak Creek requested the deposition of a representative of Noble, which we allowed. Discovery progressed, and on the eve before discovery responses were due, Noble filed a request to withdraw its application. Despite the fact that Oak Creek protested this pooling application, they objected to the withdrawal of Noble's application, citing that an argument that they would be prejudiced because Noble was taking their minerals without just compensation and would continue to do so if there were not a pooling order in place protecting their rights. Based on commission precedent as well as legal precedent that the parties agreed was the controlling standard, I issued an order allowing Noble's withdrawal of its application, simply because I'm not aware of a mechanism by which the commission can force an applicant to complete an application. Oak Creek's exception that's before you today is based on my order allowing Noble's withdrawal of its application. There was a subsequent dispute regarding the record that's before the commission that kind of took on a life of its own. I initially held that the APA prevented Oak Creek from supplementing the record because they failed to certify any record as a result of its exception. And there was 15 or 16, I can't recall the exact number, 15 or 16 exhibits attached to Oak Creek's exception, which I initially ruled would not be allowed to be made as part of the record. Otherwise, they would violate the APA. Oak Creek requested that I reconsider that. And in hindsight, the record would not make sense before the commission. It would be an incomplete record. There would be no context. So as a result of Oak Creek's request, I allowed a limited expansion of the record, which included the original motion to withdraw, the response, and the reply thereto, along with any exhibits. My order allowing Noble's withdrawal of that application, Oak Creek's exception, exhibits, and Noble's response. After I thought I took care of the issue, Noble filed an emergency exception saying that they were prejudiced because they were not allowed to supplement the record. In my opinion, I don't believe the record needs to be supplemented because I don't think any further documentation is necessary for this commission to make its decision. I think commission precedent as well as legal precedent that's cited in my order speaks for itself, and it's fairly clear, in my opinion, that Noble should be allowed to withdraw its application and Oak Creek can seek alternative remedies.
Commission Chair Benton.
Yes.
I do not mean to interrupt, but I would request at the outset of this hearing that Noble be allowed to present its emergency exception to you, which was struck from the record. It was properly filed under the APA. It's our belief that the hearing officer does not have the authority to strike the emergency exception that's properly filed. I'm asking for 2 minutes of your time prior to oral argument to present that emergency exception. And for the record, I don't think I said this is Kelsey Wazelinski, Jost Energy Law, on behalf of Noble.
Thanks. I did say Ms. Wazelinski, so
Thank you.
at least we got that, but thank you for identifying yourself. A moment, please. Okay. Mr. Peskin, what would you have to say about that?
I think it's duplicative and unnecessary. I think it's irrelevant. I'm familiar with the record. I understand the commission can look at any documents it chooses to. I don't think it adds anything to the issue before the commission to decide today.
Okay. And the issue that we have to decide is either to grant their withdrawal or not grant it, correct?
Correct.
Okay. I guess I would ask the opinion of the other commissioners if you're okay either way, although you don't think it adds to the record. This strays well and out of my area of expertise because it's legal and not engineering or anything related to that. So, but we do have the benefit of a couple of commissioners here that might have some comments on that, with Commissioner Boygan or Commissioner Overturf.
I have opinions, but you're welcome to.
Please, Commissioner Overturf.
So I do think that an exception should be dealt with by the commission rather than by the hearing officer. So I would be in support of having a very brief argument on the exception itself in order to better understand the relief that's being sought in the exception and to make a decision on the merits of the request prior to the oral argument.
Very well. Commissioner Boygan?
I'm fine with that. Noble's asking for 2 minutes to say why they should have an opportunity, as I understand it, to react to the supplemental record that was approved by the hearing officer. From what I can see, both parties are well familiar with every single document in this proceeding, so I think we ought to just get on with it, but I'm happy to hear Noble.
Okay. Well, as our attorney has said 2 minutes, so we'll go 2 minutes. Where's our timer? Okay. Please
Thank you.
proceed.
Thank you, commissioners. Again, this is Kelsey Wazelinski from Jost Energy Law on behalf of Noble Energy. Noble's emergency exception was filed on Friday morning, January 25th, and it addresses 2 rulings by the hearing officer, as Hearing Officer Peskin described, that in fact violate the Administrative Procedure Act and severely prejudice Noble in this hearing before you today. On January 23rd, after the briefing was fully closed with respect to Oak Creek's exception, the hearing officer allowed Oak Creek to designate an entirely new record. for Oak Creek's exception hearing, and this does prejudice Noble. And then on the 24th, the hearing officer denied Noble's motion to continue this hearing to the March hearing docket. So under the Administrative Procedures Act, it is Oak Creek's obligation to designate its record for its exception before you today. And this is important because the grounds of your decision to grant or deny Oak Creek's exception must be within the scope of the issues presented on the record. And that's in the statute of the APA, that's 24-4-105-15A. Oak Creek did not designate a record within 20 days of the hearing officer's November 28th order. On January 16th, the hearing officer ordered that the record would be comprised only of the hearing officer's order, Oak Creek's exception, and Noble's response, with no exhibits because to find otherwise would allow Oak Creek to circumvent the requirements of the APA. So as of January 16th, this was the record. Noble filed its response to Oak Creek's exception on January 17th, based on this record, solely on that record, and in reliance on the hearing officer's order on the record. Oak Creek waited 2 days until January 18th to object to the hearing officer's order. And on the 23rd, the hearing officer confirmed Oak Creek's violations of the APA, and yet he granted Oak Creek's untimely request to designate an entirely new record to keep the business of the commission moving forward. The new record is not addressed in Noble's response, which is in your portfolio. It contains.
Sorry, time is
Thank
expired.
you. May I move to continue this matter?
That's at the end, you'd like to move to continue this to March.
That is correct. In order to cure the prejudice to Noble, to allow it to supplement its response based on the entirely new record, Noble respectfully moves to continue this exception hearing to March.
So I have a question of the hearing officer.
Yes, Commissioner Overturf.
You amended the record after the briefing was already complete on the exception, the Oak Creek's exception. Is that correct?
Well, technically, I closed the record before Noble filed their response.
So Oak Creek filed their exception, failed to designate a record, then came to you and said, whoops, we want to designate the record to include these things.
I don't believe that timeline's correct.
Okay.
I think Ms. Wazelenki correctly recited it. I'd have to look at the email chain. There was a lot of back and forth.
Sure.
So I'm not entirely sure on that point, and I can get you an answer in just a moment.
Commissioner Overturf, I'm happy to present another overview of that timeline, if it's helpful.
Commissioner Overturf, my response to Oak Creek informing them of their incorrect understanding of the APA was sent on January 23rd, at which point I allowed the record to be supplemented in order to make it more complete for the purposes of context. I, however, did not prevent Noble from filing exhibits attached to their response. There were no exhibits attached to their response.
Okay.
Their response came after my initial closing of the record.
Noble's response.
Correct.
Okay.
Could I ask a follow-up question?
Absolutely, Commissioner Boygan.
Of the hearing officer. So as I understand it, Noble's response was based on the record that had been closed before it was supplemented. And so they had no exhibits apparently because they didn't think any were necessary. And as I understand what they're saying now is that we want the opportunity to reconsider our response because we based our response on a different record than the record that's coming in front of the commission, right?
I believe that's their argument. Yes, Commissioner.
And why do you think that's not well taken?
I think it's not well taken because the initial Oak Creek's exception had exhibits attached to it. And I did not make a specific finding that Noble could not file exhibits attached to a response.
So I'm not sure I'm understanding, but Are you saying that when you allowed Oak Creek to supplement the record, you allowed them essentially to add the exhibits that were already attached to their exception?
Correct.
So that Noble had reviewed those documents when it prepared its response.
Correct.
It's just that Noble chose not to address those exhibits because either it didn't think they added anything or because it didn't think that those exhibits were properly before us because they weren't part of the record?
Correct. And another part of my reasoning was that if you read my order allowing Noble's dismissal, it doesn't have anything to do with. I don't think that the documentation attached to the exception is relevant for the purposes of the commission's decision. So I don't think an expansion of the record is necessary in order to reach a decision on the merits of this exception. So in my opinion, it would be a waste of commission time and resources to continue this and allow the record to be expanded beyond what it already is. This was a request by an applicant to withdraw an application.
Commissioners, I believe there's a brief misstatement of facts. May I have a
Yes,
brief
you may,
moment to
but I
correct?
just dumb this down to about a second grade level here. What documents were added to the record? Can you
Oak
summarize that
Creek,
quickly?
Oak Creek attached 15 or 16 exhibits to their exception. I'm not entirely sure on the specific number. Almost every one of them had to do with the underlying quiet title action that was a result of the district court litigation. In my opinion, that's not relevant for the purposes of this.
Are all those in our portfolio?
Yes.
Okay.
May I ask one other question of the hearing officer?
Yes, Commissioner Overturf. I haven't forgotten about you, Ms. Wozlenki. Yes.
Ultimately, you denied the emergency exception on the basis that it was untimely. When do you believe was the deadline by which they should have timely filed this emergency exception?
At a minimum, prior to the portfolio being provided to the commissioners.
Okay.
Okay, Ms. Wozlenki.
Thank you. I think there's two issues here that I would briefly like to address. The first and most importantly, the hearing officer does not have the authority under the APA to strike a properly filed exception. So we do have the right to bring that before you today. Second, the hearing officer closed the record on January 16th. Noble filed its response based on that record, this record, on the 17th. On the 23rd, the record became this binder. So Noble's response in your portfolio does not address any of these materials. And it's the burden of Oak Creek to prove by a preponderance of the evidence that the hearing officer's order should be upheld or denied. Because Noble was never afforded the opportunity to supplement its response, it prejudices Noble in this hearing, which is why we're asking for a continuance.
So I think I might have missed that because I was writing something down. You said that large stack is January 23rd.
New record, correct.
What date again?
January 23rd,
All right.
the hearing officer allowed Oak Creek to designate a new record. Noble's response was based on the initial January 16th record.
The new record contains, my understanding from the hearing officer, that the new record contains the little stack plus a large stack of things primarily were dealt with the quiet title documents. Is that accurate?
The biggest difference between the two versions of the records would be the motion response and reply requesting the withdrawal of the application, so which is the subject of this exception, and the exhibits attached to Oak Creek's exception.
I might have missed something. I thought the motion was already in the record.
No, because originally Oak Creek didn't certify a record at all.
Now I'm more confused. Sorry.
If I may, my name is Jennifer Peters. I'm here on
Yeah.
behalf of Oak Creek, and I would like to be heard on this exception issue at some point, please.
Okay. Go ahead, Ms. Peters.
I think part of the confusion here is we had a disagreement with Mr. Peskin about when a record is required to be designated under the APA. Our reading of the APA is that the record automatically includes those documents this commission has to understand the basis on which the hearing officer's order was entered. Here, that had to include the motion, the response, and the reply. And so it was our belief that was already in the record and we didn't have to do anything to make that part of the record. We then filed an exception that referenced all the same documents that have been part of this case and in the COGCC's file on this matter, going back to the very first protest that Oak Creek filed. These are not new documents that Noble is not familiar with. They do relate and pertain to the background information, and that's really all it is background information about the underlying lawsuits that have now, but for one, been completely resolved. What the hearing officer is correct about, he added to the record the motion, the response, and the reply, and then the referenced exhibits in our exception, which are discussed thoroughly in the exception that Noble did in fact respond to. Noble's request for continuance, we don't believe has grounds, and it would be extraordinarily prejudicial to Oak Creek, not to Noble. These are not materials Noble is not familiar with, and they have yet to demonstrate what it is they would put in front of you and what arguments they're not prepared to make today because of these additional documents being included in the record more than a week ago. They certainly had the wherewithal within 24 hours to put in front of you an emergency exception and designate their own record. They certainly could spend the next 5 days on documents they're well familiar with to be able to address any additional arguments they want to make to you today on this exception. Lastly, I would just point out on the prejudice side, this matter has been pending for almost a full year. It was pending for almost 9 months before Noble even thought to ask to withdraw it. It was set before this commission on 3 separate hearings and continued. And we're now getting to the point where we're starting to tread on Oak Creek's statute of limitations if it's going to have to seek relief elsewhere. And further delay is only penalizing Oak Creek, whose minerals are being taken, produced, and for which no compensation is being received or their rights even being recognized because we can't get heard by this commission. So we strongly oppose the request for a continuance. We agree with the hearing officer that there's no basis to grant the emergency exception. And so we would ask that you deny both requests and get on with this hearing today.
The motion, response, and reply, who prepared those documents?
The motion and the reply were prepared to withdraw were prepared by Noble. And then we responded. I believe there was also a supplemental response and a supplemental reply. We prepared the supplemental response and Noble prepared the supplemental reply.
So at least notionally, Ms. Wazelenki, the motion and the reply would be documents that Noble would already have in hand.
That's right, but it's frankly irrelevant for this purpose. Noble filed a response based on a record that completely changed a few days later. And I'll also note that the hearing officer acknowledged that Oak Creek's reading of the APA was wrong. They didn't comply with the rule. And he acknowledged it to Oak Creek. And yet, despite the failure to comply with the APA, he allowed Oak Creek to designate a new record. Noble's response doesn't address that new record. It's prejudicial to Noble.
Just a moment, Mr. Peskin. I may have another question.
May I ask Mr. Peskin a question while you speak?
Absolutely, Commissioner Overturf. Any help that you could provide?
The motion to supplement the record, was there an opportunity for Noble to respond to that, or did you?
Are you referring to the emergency exception by Noble?
No, I'm referring to
Their
Oak Creek's request to supplement the record.
That was through an email chain. So that gets into a weird situation where we're not a court issuing orders that have formal responses and replies. When hearing officers encounter argument through email. And so anybody's free to respond at any moment. I quite frankly don't know when parties will respond and when they won't. And I'm looking at the email thread now. So Oak Creek's initial objection, if you want to characterize it as that, was on January 18th. Their objection to my finding that the record was closed. I responded to them on the 23rd, telling them why I disagreed with their interpretation of the APA, but for the purposes of context and allowing this to move forward, I would supplement the record. That was on the 23rd. Ms. Wazelenki responded on the same day on the 23rd. Oak Creek responded to that on the 24th. So to answer your question, there was some back and forth between the parties.
Okay, thank you. I am prepared to make a motion, but I want to make sure you have an opportunity to ask your questions.
Can I ask one more question before
Ask as many as you want.
Commissioner Overturf does that?
Yeah.
I'm not sure even who I'm asking this question to, either the hearing officer or counsel. But I'll start with Ms. Peters. Would it be a fair statement that since you disagreed with the hearing officer's interpretation of the APA on certification of the record, that you would have filed an exception with us for this hearing on the issue of the contents of the record?
That's a difficult question to answer, partly because we didn't cross that bridge. I have to say I agree with the hearing officer in one respect, in that the documents that comprise the supplemental record are really background information. Our issue with the hearing officer's order is with his conclusions of law here. We disagree with his interpretation of the statutory authority that this commission has. And so while those documents give a complete picture of what's happened here, I agree with him that they're not going to be the definitive factors. So whether or not we would have filed that exception, I can't say 100% for sure.
So what I'm hearing is that everybody agrees that the documents are irrelevant and shouldn't be the basis for any action that we take. The hearing officer nevertheless let them come in, but is basically telling us to ignore them. And Noble saying, well, they're in the record, so we have the right to respond to them, even though I'm really hearing everybody say that the documents are irrelevant anyway and probably shouldn't have even come in. I think the process here has been terrible, frankly. This is not the way to run a railroad. This is not the way that we can function. And what I would have said, I think, and with the benefit of hindsight, is if you think the hearing officer is wrong on the certifying the record, take it up to us. We'll consider it, even though it seems like everything that you've added to supplement the record, everybody agrees is irrelevant. But to say that they missed the date for doing it, and then allow them to file the material anyway, but then to tell us we can ignore it because it's irrelevant, to me, it's bad process. And so I don't want to continue this thing. Everybody's here. I think we ought to argue the merits, and I think Noble ought to be allowed to maintain their exception. And if they think at the end of this proceeding that they were prejudiced, they can file a motion for some kind of relief, and we can consider it. But I don't see any reason to continue this thing.
Okay. Just a moment, please.
Mm-hmm.
Commissioner Overturf?
Yes, so I agree with Commissioner Boygan that I think the process here has unfortunately fallen short. I think in part that's due to our lack of an e-filing system. So hopefully once we get that up and running, there will be more clarity about what is a communication that is strictly procedural with one of our hearing officers and what is a motion that is seeking explicit relief, and that there can be additional clarity to the parties about what is happening. Unfortunately, we haven't been able to implement that yet, but any day now. But in light of that, recognizing that we don't have that kind of an e-filing system and we're stuck with the facts that we have, which I agree are exceptionally bad and complicated, I kind of fall back on there was this kind of informal motion made via email. There was not an immediate response within that. I suppose it was 5-day period between when the request was made and when it was granted by the hearing officer. Noble could have responded within that time to raise an objection to the relief that was being sought by Oak Creek. They didn't. Also within the balance of what we all understand, which is that the things that were allowed into the record are of limited, if any, substantive value. I think the prejudice to Noble is exceptionally low. And so I would recommend that we either, well, I guess for the sake of clarity, I would recommend that we deny the emergency exception and move to the motion, to the merits. And I'm moving that.
Do we need to move that because there's a motion here, we can deny that, right?
Sure, so my motion would be to deny the emergency exception.
All right, procedurally, that's the right way to do it.
Commission
well.
Chair Benton, may I clarify the record?
Yes, ma'am, go ahead.
Noble did file a response to the hearing officer's designation of a new record. That was done via email, and that was done in the emergency exception. So the emergency exception is addressing two rulings. The January 23rd expansion of the record, Noble objected to that, is seeking that you hear that exception before you today, and the denial of the continuance on January 24th. So Noble did respond to that via the email and via emergency exception.
So other than the continuance, which you've moved for continuances, tell me again, are you asking for something else today?
I believe it's an either or. If you continue this hearing and Noble is allowed to supplement its response, then we would no longer object to the new record. However, if you deny the setting of the new record by the hearing officer, Noble's prepared to move forward today based on the record that was designated on the 16th.
Very well, and I believe that's what I heard was a motion to deny the continuance and proceed. Is that correct, Commissioner Overturk?
I think inherent in denying the emergency exception is denying the continuance, which was the relief requested in that emergency exception.
Is that,
I agree with that.
That's how you interpret that?
I just want to be, Ms. Wazelenki said that if we deny the continuance, Noble's going to proceed on the basis of the record before it was supplemented. And my reaction is that's Noble's decision. That's not, we haven't decided that. Essentially, if we deny the motion for continuance and we deny your exception, we're basically not overturning the hearing officer's certification of the record, supplementing of the record. And that's the record, therefore, that's in front of us. You know, if you think you have recourse at the end of this hearing based on that, you'll have to pursue it, is the way I'm.
Thank you. And on behalf of Noble, we just need to make a record of the prejudice here.
Fine.
fine. All right, is there a second to Commissioner Overturk's motion?
I'll second it.
Seconded by Commissioner Boygan. Any discussion? Does it need to be clarified?
I don't know, does it?
Pretty much said, what I heard is it says, let's proceed. Very well. All in favor, say aye.
Aye.
Aye, but we're proceeding on the basis of the supplemented record that the hearing officer approved.
Yes, I got that part. So you're clear on that. All right, let's proceed. What do we do? Because I didn't see a pre-hearing order there. So what process do we go through here? Mr. Peskin?
In my opinion, it should be the evaluation of my order dismissing Noble's application.
Okay. Is there a formal presentation by either party that goes along with this, or?
This is a first for me, Chair Benton.
If you'd like.
Yes, Ms. Larson, what would you like to propose here?
Thank you. Thank you, Mr. Chair. So correct me if I'm wrong, Hearing Officer Peskin, but it's 15 minutes of oral argument for each party?
That's correct.
Okay, thank you. And Oak Creek will begin. And forgive me, no, Commissioner Boygan, do you have a question?
I would
missed
have
that.
expected the hearing officer to present the substance of what he did, his order.
Certainly,
What it,
certainly.
before we hear from the parties.
Of course, yes. So Hearing Officer Peskin is certainly prepared to go ahead and provide the Commissioner's summary of what his order was, and then we'll proceed to allow the parties to speak to that.
I apologize for missing something in here that said who got to present and for how long.
No, it's, I'm not, yes. I'm not sure if it made it into the recommendation.
I
So,
didn't see it in
It may
there.
not have.
So, all right. So we'll proceed with, I believe, Mr. Peskin's analysis, and then we'll hear from each party for 15 minutes.
Thank you, Chair Ben. As I stated earlier, this was a pooling application that was filed by Noble in March of 2018. It was amended approximately a week later. This dealt with 8 WSUs in GWA. Following the submission of the application, there was a protest filed by Oak Creek. My understanding of the basis for Oak Creek's protest is rooted in the fact that in the application lands, there were mineral heirs, owners of mineral interests that were heirs that were part of a district court quiet title action. Oak Creek subsequently obtained ownership of other mineral interests that were also tied to that same quiet title action. Oak Creek engaged in a quiet title action in the district court, which dragged on from, I believe it originated in 2016. I'm not entirely sure about that, but it went through 2017 and into 2018. The people that were the defendants in that quiet title action are known as the Flynns. So basically the district court in the quiet title action found that the Flynns had committed fraud on the court because they knew or should have known about these other mineral heirs out there, and ended up setting aside a quiet title action. That was in their favor. Reopened it and found at the end of the day that Oak Creek was a rightful owner in some of these minerals. The important thing as far as my analysis of this case with regard to the timeline here is the fact that the district court's decision that Oak Creek was a rightful owner occurred after the filing of Noble's application, their pooling application. That was discussed here during pre-hearing conferences, at which point, as I said earlier, that Noble no longer disputed the ownership, Oak Creek's ownership interest in these minerals. It was following a ruling that allowed for a limited amount of discovery, including a deposition. It was following that timeline just prior to when discovery responses were due by Noble, that Noble requested its pooling application be withdrawn in a motion to dismiss, or in the alternative, a motion to withdraw. Oak Creek objected to that motion on the basis that if Noble's request was granted, that Oak Creek would be prejudiced because Noble would continue to take their minerals without compensation because there would be no pooling order in place. During the course of the motion, response, and reply, both parties agreed in the controlling precedent of Powers v. Professional Rodeo Cowboys Association, which is 832 P. 2nd 1099. There are 5 factors that case stands for the proposition of when a plaintiff should be allowed to withdraw its lawsuit in the event that there might be prejudice to the defendant, which Oak Creek was asserting would occur if Noble was allowed to withdraw its application, they would be prejudiced. So both parties cited this case in their motion and response and reply, and the 5 factors that I use to evaluate in the analysis: number 1, the duplicative expense of a second litigation; number 2, the extent to which the current suit has progressed, including the effort and expenses incurred by defendant in preparing for trial; number 3, the adequacy of plaintiff's explanation for the need to dismiss; number 4, plaintiff's diligence in bringing the motion to dismiss; and number 5, any undue vexatiousness on plaintiff's part. You've all seen the order, it's part of the portfolio, but I found that all of these factors weighed in Noble's favor, with the exception of the 4th factor, which was plaintiff's diligence in bringing the motion to dismiss. So despite the fact that there was only 1 factor in Oak Creek's favor, my finding was that did not tip the scales in their balance. That, in conjunction with the fact that it's been commission precedent that if an applicant wishes to withdraw an application, it's allowed to do so. We don't have a rule. There's no statutory provision that allows the commission, as far as I know, maybe someone will correct me, that allows the commission to force an applicant to complete an application. So based on those factors, as well as commission precedents, I allowed Noble to withdraw its application.
That's all
That's all.
for now.
I hope so.
Thank you. All right. Ms. Larson, I'm assuming that Oak Creek would speak first?
Yes, that is
Okay.
correct. And
All
again,
right.
it's 15 minutes for each side.
Okay. And again, please remember to identify yourself.
Certainly. If I may, if we're ready.
Do we have any witnesses that we need to swear?
No, we had understood this was just oral argument.
Okay, very good.
My name is Jennifer Lynn Peters. I'm the attorney here along with my colleague Timothy Odle for Oak Creek Oil and Gas LLC and Oak Creek Oil and Gas 2 LLC, both of whom protested Noble's pooling application that is the matter before you. I recognize that with the procedural jumps and hula hoops that we've gone through and that you've heard a little bit about today, this feels like a complicated case. I assure you it is not. What happened here is that the district court set aside a quiet title decree that said the Flynns, who had leased their interest in the subject oil, and I'll get to exactly what we're talking about in a moment, to Noble, leaving the state of the record as that interest was owned by the heirs of Anna and Bernal Madison. What we're talking about here is a half interest of oil rights underlying Section 6 in the south half of Section 6 in Township 5, Range 62 West in Weld County. The other, we're talking about approximately 160 net mineral acres of oil rights. The other 160 of those net mineral acres are owned by Wells Ranch. Of those, there were 32 heirs that should have gotten notice and been involved in leasing these minerals. Only 3 of them leased to Noble. Oak Creek has either leased or purchased the mineral rights of 28 of those heirs. They now own almost 7/8 of this interest. The Flynns own 1/8. And there is one tiny owner that has 1/320th of the interest who has not responded and has not participated in any proceeding. The hearing officer gave you a little bit of background about why this quiet title decree was set aside, in that the district court found, prior to this pooling application being filed, that the Flynns had misrepresented that they were the only heirs, that they had defrauded the court essentially and claimed the entire interest. The part that he left out was the district court's findings were based upon the knowledge that the Flynns had from the research file they were given by Noble Energy back in 2009 and 2010. All of the same information that led the district court to say the Flynns knew better that they weren't the only heirs came from Noble, and Noble had it in its possession as well. Noble knew back then, when they first filed a pooling application over these subject lands before this commission, that it had not identified all the heirs and had trouble finding them. They chose to lease for the Flynns before the quiet title decree entered, and then chose voluntarily to withdraw their first pooling application over these subject lands. That's why we're here today, ladies and gentlemen, because they didn't proceed as they should have back in 2010. Fast forward to 2016, Oak Creek discovers that there's a lot of heirs out there who didn't get notice of this, contacts them, leases or purchases their minerals, goes to the district court to try to make this right on their behalf. Gets the order setting aside the decree in February of 2018. A month later, without telling Oak Creek, Noble comes to this commission and filed the pooling application that's the process before you today. They notify and list and identify every single heir, their address, and the Flynns that was identified by Oak Creek as being an owner, deliberately excluded Oak Creek. Tried to push this past us, in other words. They tried to get to you to get a pooling order before Oak Creek ever found out about it. Oak Creek found out and protested. And I want to clarify what our protest was about. In the protest, Oak Creek did not seek dismissal of this pooling application. We agree pooling is the correct process that has to happen here, and it's the only process that can rectify and remedy and protect the correlative rights of the parties here. What we said was they should have given us notice and they didn't. So you have to correct that first. Through the back and forth procedure that happened over notice, that issue got taken care of and Oak Creek was allowed to participate in the case as a party. From that point on, all we have ever asked for and said is that Oak Creek should be given what its statutory rights are under the pooling statute. 3460-116 makes it clear that when you go to pool, you have to give any owner, whether they own a leasehold or they own the interest, the right to consent to either participate in the process or to lease before a pooling order is entered. All we have said here is that right to consent choice should be given to Oak Creek here by Noble, and then if they choose not to reach agreement, a pooling order should enter. Noble has resisted and at every turn tried to take the unsupported position that because there was not a district court order confirming Oak Creek's interest that it obtained in 2016, it did not meet the statutory definition of owner under your statutes, 3460, I believe it's 102. That's the only issue that was headed for hearing before this commission last December, and but for this withdrawal would have come before you in December. Was that interpretation of the definition of the word owner in the pooling statute and whether or not it applied to Oak Creek. There's no dispute about the facts here. There's no question about the timing of what happened. There's no question about that Oak Creek obtained deeds, that they were recorded in 2016, that the quiet title decree was set aside, and that the order confirming the interest entered after this pooling application was filed. All of that is not in dispute. The only question is one of statutory interpretation that this commission under the law has to decide first, because it's your governing statute that you're interpreting and it's your obligation to enforce. When we were on the eve, and it wasn't quite the eve of discovery responses, the day their discovery responses were due, Noble said, hey, you know what? We want to withdraw our application. And absolutely Oak Creek said no, because if you withdraw this application, you leave the parties in an uncertain scenario. What happens here? The COGCC is the only authority the only body who has the authority, the jurisdiction to decide and allocate and pool interests, to determine and protect the correlative rights of the parties in the same oil, which is what we have here. If it's not pooled and there's no agreement between the parties, what happens? And that's the situation Noble is trying to leave us in here today. That's why they wanted to back off before they had to give Oak Creek the statutory rights it's entitled to as a joint owner in the subject oil. What we take issue with the commissioner's, with the hearing officer's order is in his determination that there's no authority that vests you with the ability to tell an operator they have to pool an interest. Your statutes, the pooling statute, 3460 106A3, they all talk about your obligation as a commission and your duty as a commission, your powers as a commission, is to ensure that orders are entered to allocate production on a fair and equitable basis so that each is permitted to produce no more than it's just an equitable share. That's 3460 106.3A. The pooling statute, 3460 116, says that pooling order shall be entered upon terms and conditions that are just and reasonable and that afford to the owner of each interest the opportunity to recover or receive without unnecessary expense his just and equitable share. This is something that falls within your authority, ladies and gentlemen, and all Noble has ever said, and what the hearing officer apparently agreed with without much analysis, was that the district court should resolve this dispute because there's a pending court case in which we seek damages, money damages from the Flynns. There's no dispute about title. The Flynns have not said that the ownership is not as it was determined by the court. In fact, the Flynns consented to the entry of those orders. The Flynns are not claiming they're entitled to any more than 1/8 of the proceeds from this production. The only issue is whether, because of their fraudulent actions, they owe Oak Creek additional money damages. That issue does not affect the pooling of rights between parties here. It has no effect on whether or not Noble has the authority to continue to produce without paying or recognizing Oak Creek's interest. They have done this, ladies and gentlemen, since 2016, when they first got notified by Oak Creek in September of 2016. They were told, hey, we have this interest. They immediately suspended payments on this subject oil. They've been producing continuously on very successful horizontal wells since 2016 and not paying a dime to any owner, the Flynn's or Oak Creek. And these are the only parties who claim an interest. There's no one else coming forward saying there's an interest here. So there's no title dispute, as the hearing officer confirmed. So the hearing officer's conclusion that that 2017 case was going to in any way impact this was incorrect legally. I believe he was somewhat persuaded by Noble's position that it's not fair, that they might have to pay twice because they already paid the Flynn's on the vertical wells between 2010 and 2016. The law already allows for how to handle that. It's called set-off. And this commission has the authority in its pooling order to enter or to include language that would say that to the extent part of the recovery that comes from the Flynn's to Oak Creek accounts for royalties they improperly received in 2010 to 2016, those should be set off against any obligation Noble has to pay. You don't have to defer any action. Let the parties sit in this no man's land where Noble continues to take without payment and without recognition of a significant owner's interest, just to determine what that dollar number is. We know what the dollar number is. If Noble would provide an accounting like they promised, we would know the exact dollar amount we're talking about that was paid to the Flynn's that's at issue. But my point is, it's easily quantifiable. It's easily addressed by this commission. So there's no possibility of inconsistent orders on who gets paid what amount. What isn't before the district court in any way, shape, or form is how much Noble must pay to Oak Creek for its interest here, because it continues to produce without agreement and without a pooling order. And that's something that under the pooling order statute, under sections 3460, 102, 103, 105, 106, and 117, only this commission has jurisdiction to provide. Now, Noble, like has said, and the hearing officer's order says that it's the district court that has to resolve this dispute, that's one area of relief that Oak Creek has. It could go to district court. Respectfully, again, his legal conclusion there is wrong, because this commission has the exclusive jurisdiction here. And Noble has not yet offered any mechanism or manner for why it is they believe the district court could step in and essentially force pool this interest and determine who's entitled to what royalty from the production and allocate the correlative rights of the parties here, when that's something this commission has the authority to do under the statutes. And we all know what happens when people rush to court and say, you should do this because we need this right. They're going to say, go to the commission. That's who enforces this statute. Go to the commission. They're the ones who have to interpret their own statutes, whether or not you're an owner. The other piece I want to make sure we take an issue with the hearing officer's order. He found that there would be duplicative expense, that there wouldn't be duplicative expense of going forward. The result of withdrawing this procedure, this application, essentially takes off the table that definition that the only issue we were fighting for the last year. The only issue that was pending in this case was whether or not Oak Creek fell under the definition of owner and therefore was entitled to the protections of the pooling statute, based on the timing this application was filed, because Noble was sticking to the date they filed was absolutely determinative, and they were adamant it had to be confirmed by court order to meet that definition. We disagree. That was the only issue. That issue is no longer on the table and will not be fought in any proceeding, whether it goes to district court, whether we're in front of you on a new pooling application tomorrow. That issue doesn't repeat because it's all tied to the timing of when this application was filed. And I would submit to you that it is not an efficient use of anyone's resources, including yours, to say to Oak Creek, well, we're going to let them withdraw because that's been our precedent. And your remedy is you get to refile as an owner a pooling application and start the process over. That makes no sense, nor is it the process this commission should authorize. I can't speak to what the history of this commission has been when an applicant has come before you and said, we want to withdraw our pooling application, over an objection of a protesting party who's never been given a good faith lease offer or well proposal and whose interests are otherwise not being recognized. I don't know what your precedent is there. I submit to you, though, that it should not be, and if it has been to allow that application to be withdrawn just because that's what you've always done, you should look really hard at that. That's not the way this should work.
How are we doing on time?
Okay.
38 seconds.
I think with respect, I would reserve the last 30 seconds to correct anything or make any responsive arguments to
Very
Ms.
well.
Weslinkie.
Ms. Wazelinski.
Thank you. This is Kelsey Wazelinkie from Jost Energy Law on behalf of Noble Energy. So this is exception hearing before you today is not about Noble's prior due diligence or the due diligence of the Flynn's attorney in 2010. It's not about allegations of bad faith against Noble, and it's not about what Oak Creek wants. They clearly want a pooling order. The Commission's review of Oak Creek's exception is very narrow and it's constrained. The APA and legal precedent provides that the Commission can only overturn the order if the evidentiary conclusions of fact are contrary to the weight of evidence, and if the ultimate determinations of fact are unsupported by any competent evidence based on an incorrect legal conclusion applied from the underlying facts. These high standards are intentional, and they're in favor of upholding the hearing officer's order in this matter. In this hearing, Oak Creek has the burden of proof to show by a preponderance of the evidence that the hearing officer's findings are incorrect. Oak Creek cannot meet this standard of review, and therefore the exception must be denied. There are 4 legal bases for Hearing Officer Peskin's order in this matter. While all four of the hearing officer's legal bases support the order, affirmance of any one of them is sufficient to uphold the order. Under Noble's recent review of the new designated record in this matter, there is no evidence before the Commission that would contradict these findings. So the first legal basis of the hearing officer's order is the application of the 5 factors in the powers test, which Hearing Officer Peskin described to you earlier. With respect to duplicative expense of second litigation, he found that the expenses associated with a second litigation are mitigated by the information gathered by Oak Creek in this matter. There's evidence to support this ruling in the record. Exhibit 8 to Oak Creek's exception is a deposition of Steve Hawthorne. He's Noble's landman. Exhibit 9 to Oak Creek's exception is Noble's response to Oak Creek's interrogatories. Oak Creek has gained access to significant discovery in this matter that it can use in a second litigation. With respect to the extent that the case has progressed, Noble's motion to withdraw, as found by the hearing officer, was filed more than 2 months before the application was set to be heard before the Commission. And it was filed before the completion of discovery and, as found by the hearing officer, a host of other necessary filings as dictated by the case management order. There's evidence in the record to support the hearing officer's findings. First, Noble's motion to withdraw, which is in the record, filed on October 12th, 2018, more than 2 months before this matter was initially set to be heard before you. In Noble's reply, which is in your record, to Oak Creek's response, it lists the remaining deadlines in the case. While the application had progressed, there was still significant briefing to be had in this matter. With respect to the third point, the adequacy of Noble's explanation for its need to dismiss, the hearing officer found that underlying district court and court of appeals actions, quote, add layers of uncertainty and complexity to any potential Commission order on these issues. There's evidence for this finding in the record. Noble's motion to withdraw its application cites the 2018 reinstatement of the damages case by Oak Creek against the Flynn's. This will have an impact on this pooling application that Noble's seeking to withdraw. Noble's motion also cites the Flynn's notice of appeal in the Court of Appeals, challenging the Weld County District Court's authority to reinstate this case. Now, Oak Creek's exception did contain an order from the Court of Appeals dismissing the Flynn's appeal against Oak Creek. However, this was entered over 1 month after Noble filed its motion to withdraw, and shortly before the hearing officer entered his order. The hearing officer had no access to this decision when he entered his order, and it was not originally designated in Oak Creek's record. And nevertheless, the pending damages case between Oak Creek and the Flynn's supports the hearing officer's finding of uncertainty with respect to pending litigation. Fourth, with respect to Noble's diligence in bringing the motion, this was the one factor that the hearing officer found against Noble. However, while Noble could have been more diligent in filing the motion, this factor is not enough to change the outcome of the order. Fifth, any undue vexatiousness on Noble's part. The hearing officer found that there was no undue vexatiousness on Noble's part. This is based on evidence in the record. Exhibit 2 to Oak Creek's exception cites an order from Judge Hartman. He's a district court judge. He found that the Flynn's attorney failed to exercise due diligence, and Noble passed the baton to the Flynn's attorney to finish that research, and she never did. As a result, the 2011 quiet title decree was entered, and Noble properly relied on that. There is no bad faith by Noble with respect to the title history before you. The hearing officer found 4 out of the 5 of these factors weigh in Noble's favor, and that the single factor that the hearing officer found in favor of Oak Creek, that Noble could have been more diligent in filing the motion, was not enough to change the outcome of the order. Accordingly, under the law, the hearing officer's findings of evidentiary fact must be presumed correct. Because his evidentiary findings of fact may not be disturbed, his ultimate determinations of fact regarding each of the 5 factors must stand. There is competent evidence to support them, and Oak Creek has agreed and does not challenge here that the hearing officer has applied the correct legal standard. Now, the second legal basis of the hearing officer's order is his finding that granting Noble's motion to withdraw, quote, comports with the commission's precedent, allowing parties to voluntarily withdraw their applications. Oak Creek's exception does not challenge this ground, and therefore Oak Creek has waived or abandoned any argument that the order does not comport with precedent. Nevertheless, there's support in the record for the hearing officer's determination. Noble's motion states that there is no commission rule governing the withdrawal of a pending contested application before you. To that end, we applied the Colorado Rule of Civil Procedure 41A, which provides that applications may be dismissed voluntarily or upon court order on terms and conditions that are just and reasonable. And as just discussed, Noble's withdrawal meets the 4 out of the 5 factors of the powers test. The third legal basis of the hearing officer's order is his finding that there was no mechanism, rule, or statutory section allowing the commission to force an applicant to complete its application. Again, Oak Creek's exception in your record does not challenge this ground, and therefore Oak Creek has waived or abandoned any argument that an applicant can be forced to complete its application. Instead, Oak Creek argues the alleged harm to it and what it wants. Oak Creek wants a pooling order. Frankly, that's irrelevant to the exception. As the hearing officer states, this is Noble's application, not Oak Creek's. Nevertheless, there's support in the record for the hearing officer's determination. In the record, there is no evidence to contradict this finding. As cited in Noble's motion, there is no commission rule governing the withdrawal of a pending contested application. The Colorado Rule of Civil Procedure 41A provides that applications may be dismissed voluntarily or upon court order on terms and conditions that are just and reasonable. And as we all just went through, Noble met the powers test. The fourth legal basis of the hearing officer's order is his finding that concerns regarding inconsistent verdicts and the fact that Oak Creek has other commission and district court available to it to resolve the present issues persuades the hearing officer to grant Noble's motion. To the extent Oak Creek addresses this finding in its exception, Oak Creek relies on argument of counsel. And under precedent, that's not evidence and does not substitute for a proper appellate record. Oak Creek's exception failed to designate any part of the record or plead any facts that the hearing officer's findings are contrary to the weight of evidence. Nevertheless, there's evidence in the new record to support the hearing officer's findings. In Noble's motion, Noble cites the 2018 reinstatement of the damages case by Oak Creek against the Flynn's in district court. Exhibits 2 and 3 to Noble's reply cite Oak Creek's damages for payments for allegedly taking Oak Creek's minerals. Noble's reply cites 2 payment of proceeds applications filed by Oak Creek in docket numbers 1810-00868 and 1810-00867, which are pending before you. Oak Creek has frankly committed many slanderous attacks against Noble in this matter, and they've wrongfully painted Noble as a bad actor, and they misconstrue the findings in the underlying airship proceeding, which are irrelevant to the determination of Oak Creek's exception before you today. Oak Creek has not met its burden of proof here and has not shown by a preponderance of the evidence that the hearing officer's findings are incorrect. And for these reasons, the exception must be denied and the order must be upheld. I would like to reserve my remaining time. Thank you.
Which is how much, Ms. Larson?
6 minutes and 2 seconds.
Very well. Ms. Peterson, Want to spend 38 seconds?
I would, thank you. I just want to point out first and foremost, the payment proceeds matter that was referenced. Immediately upon being allowed to withdraw this application, Noble filed a motion to dismiss those proceedings because, in part, there is no pooling order establishing who's entitled to be paid what. So again, we're caught in a very unique situation here that Noble is creating, where we're in an untenable situation about what is this owner supposed to do. There should be a pooling order, and then if there's not payment, you do a payment proceeds case. Here, we can't get either done, and Noble seems to want to live in that scenario. I would also just note that we seem to have a disagreement about findings of fact versus conclusions of law. We are attacking conclusions, not findings. And everything she referenced are conclusions,
Ms.
not
Peters,
findings.
your time is up.
Thank you, Ms. Peters. Ms. Wozzelinski?
Very briefly, again, the burden is on Oak Creek here to show by a preponderance of the evidence that the hearing officer's findings are incorrect. Based on the reasons that I just described and the evidence in the record to support the findings, Oak Creek has simply not met its burden. This is frankly not about what Oak Creek wants. This is Noble's pooling application. There is no precedent, and I think it would be a dangerous precedent for the commission to force an applicant to continue with an application before you. So for the reasons that I've stated, Oak Creek has not met its burden and its exception should be denied. Thank you.
Very well, thank you. Thank you all. Are we, now at this point, we could probably ask some questions if we wanted to.
Yes, you may, certainly.
Commissioners?
Sure. My question is, could we take a quick break?
Yes, we may. We'll reconvene at 2 o'clock.
Great, thanks.
Go ahead.
I was just going to damp that.
Oh, okay. So. Very simple. Your mechanism really allows us to tell them. Ms. Larson, I think we're still in the, whether or not there's any questions or comments, and I think the first question was a request for a break from Commissioner Boygan. So now that we're back, it gave you probably some opportunity to think of something to say.
Well, I have a lot to say.
Very well. Do you have any questions?
I'll start, to your great surprise. So, Ms. Peters, I have a question for you. What exactly do you think you would accomplish by getting a pooling order? What do you think it would do?
So the pooling order here, as I understand the statutes, to produce here, the operator needs either agreements through a lease or a participation agreement or a pooling order in order to take oil out of the ground, which is what's happening here without a pooling order and without agreements. The pooling order would establish who owns which rights and would protect the correlative rights of the parties here by saying this is how it's going to be allocated and who gets paid what going forward.
So you see the pooling order as kind of a quiet title proceeding by this commission?
There is not a quiet title proceeding or decision to be made here. Ownership is not in dispute. There is no question about who owns the subject oil here. And Noble has conceded that. The only question for them was whether they were entitled to pool without making a well proposal and giving Oak Creek the chance to consent that the statute allows for, because they filed their application to pool prior to the district court entering an order, to use Noble's word, confirming the ownership interest that was already in place. So there's not a title question to be decided here by the pooling order. The pooling order would do what all your pooling orders do. It would allocate and set the rights of the parties in and to the proceeds from the production of oil that right now Noble continues to take without a pooling order and without agreement.
And are you saying that that Oak Creek has no common law remedy against Noble, that it needs a pooling order in order to recover damages from Noble for proceeds that Oak Creek says were improperly paid?
So I think what you're asking about is this issue about past proceeds, but the stuff that was paid from 2010 to 2016, right? I think, what needs to happen first and foremost is a recognition that in order to continue to produce, the correct ownership and allocation of the rights of the parties needs to be made. And then, for instance, one thing this commission could choose to do is say, we don't have the authority to decide. I disagree, but I think you have the authority. But you could say, we're not going to decide the past proceed case. We're going to decline jurisdiction. And I think you have to, if you're going to do this, you have to specifically state why you're declining to exercise jurisdiction over that dispute. And then we can go to court. But until you do that, I can't take this matter to the district court, because you have, as a commission, the exclusive authority to decide and state what the just and fair allocation of production of oil and the proceeds from that production is. It has to go through you. That just and fair allocations is in both the pooling statute and in other sections of 3460. And so we believe that's something you do all the time in making pooling orders, and that's what needs to happen here, because we have a situation where, like other cases that get pooled, right? You have an operator who's producing and they don't have a lease or a participation agreement with the owner. So that requires pooling.
With all due respect, and we'll get into our deliberations, no, it doesn't. You have a common law action that you can file. What I'm hearing you say is that a pooling order by this commission would allocate rights and proceeds among the parties, and that you need us to go through that process before you would have any remedy in court to seek damages from Noble for what you say are improper payments, both in the past and on a going forward basis.
Well, let me be clear. I mean, I think there's an obligation, and this would be the first argument Noble would make if we were to file a case in district court, is that we have not exhausted our administrative remedies before this commission. I think yesterday you saw a similar case with the Larsons where they've made that exact same argument. And the owners here are in a very difficult position. What are we supposed to do? We have to exhaust our remedies before you, and you have jurisdiction unless you decline to exercise it. And the hearing officer did not determine that you don't have jurisdiction. He allowed the withdrawal based on incorrect assumptions about whether or not you have authority to go forward with a pooling application, even if the operator says, you know what, we'd rather just keep stealing these minerals without
So,
any agreement in place.
I'm sorry. Is it your position that Noble can be forced to pool you?
Yes. And that's one of the things the hearing officer found, right? One of the reasons he said he could be withdrawn is because his conclusion was Oak Creek could file a pooling application. Well, what's the efficiency of that if we're going to end up right back here where we are today? We were right ready to be heard on the merits of the pooling application. And what you're saying now is, okay, we're going to let them withdraw it. You must start over and file your own application. That seems like a waste of everybody's resources.
I don't know if and would it be your understanding that that if a pooling order was entered, that it would have retroactive or only prospective effect?
I think, I don't want to get this commission caught up in that it has to punt the whole thing to decide the matter going forward when there's no dispute. But knowing the facts of the case at the time, Noble filed its application seeking to do it from the beginning of time. That's what they were asking be done. So I think you absolutely could, and based on the application that's pending, that's what you're being asked to do. And again, I would point out that just and fair language in the statute allows this commission and gives you the power and the authority to say, all right, if we're going to pool from the beginning of time, how do I allocate both the stuff that hasn't been paid out, which is only pre-2016 from the vertical wells? Maybe you sever off the vertical wells and you don't pool those. Maybe you only pool going forward on the horizontal wells, where nobody has taken any inconsistent position about where those should be allocated. The Flynns are not saying they're entitled to more than 1/8 of those proceeds. Noble's not challenging the status of title as it exists today, and that Oak Creek owns almost 7/8 of those interests. So if the issue is that pre-2016, there are mechanisms available for you to still enforce the statute as you're required to do, and take that issue off the table, or to otherwise figure out what's just and fair with regard to the 2010 to 2016 vertical well proceeds.
I'm happy to let somebody else take the floor for a while.
I just have one question.
Commissioner Overturf.
And I won't belabor it, but let's say that we were to adopt your Oak Creek's position and require Noble to continue to pursue its application. You agree that Noble would bear the burden of proof in the pooling order application, correct?
I believe that would be correct, but let me be clear. The only thing that's left is the hearing. And if they have complied, if they've given us the statutory rights that we're entitled to, which is essentially the well proposal, we're really here because Noble doesn't want to make a well proposal. But there would be no fighting over, there's really no issue in terms of how it should all be allocated.
Okay, so just to interrupt you there, because I think I'm asking sort of more general questions about
Sure.
the ramifications of the relief that you're seeking here, rather than the specific circumstances of this particular case. Let's say that we were to require an applicant to proceed with a pooling application. You acknowledge that the applicant would continue to bear the burden of proof. You agree with me that there are certain requirements an applicant needs to satisfy before a pooling order can be entered, correct?
I agree.
And so let's say that Noble is forced to continue with a pooling application, but does not provide information to the other owners in the pool that identify the location and objective depth of the well, or the costs of the well, or the spud date, or the other requirements, the information they are required to provide to other owners within the parcel. We would have to deny the pooling application anyway. What I'm saying is that by forcing an applicant to go down a pathway where they bear the burden of proof and have to make meet certain threshold findings, how do you force an applicant to do that?
Well, and I agree, I understand the concern you have. And here's my question. If the other outcome is that Oak Creek has the right to file an application to pool, it's not the operator. And yet those same requirements have to be met to pool. How would Oak Creek ever get to a pooling order situation if Noble doesn't provide those opportunities? In other words, if you have to give a well proposal, the cost information has to be provided to the owners. There are 3 of them essentially here. If we have the right to file that pooling application and we then bear the burden of proof, and you could, I think, shift the burden of proof to the party wanting to go forward in this proceeding if you felt that was the just and fair thing to do. But how would it work then that the operator is in the opposite seat and it's the only one with that information and it's the one that has the statutory obligation to protect the correlative rights by making the opportunity to consent available to the owners? That's what the statute requires to pool, but the statute also says an applicant could be an owner. How would that work? What we're saying is, instead of going down that new path and trying to chart new ground and going through a whole new process that would take significant time, we're already set to go to hearing on this right now with Noble's application. And then that's why withdrawal should not have been allowed because there isn't another remedy available as identified by the hearing officer.
Okay, that was my only question. Thank you.
I'm still somewhat confused, Ms. Wozzelenki. The primary reason for your desire to withdraw the application is?
So Noble's made it very clear in the briefing on this matter that it filed its application in March of 2018. Upon the filing of its application, circumstances in this case and title to the minerals changed tremendously. And Oak Creek's title didn't vest until June of 2018. Since this change in circumstances, Noble has made it very clear that the proper remedy to the parties available to both Noble and Oak Creek is in the district court. So Noble's position right now is that the proper relief is in the expertise of the district court to grant an equitable remedy. You have wells that were drilled between 2011 and 2016. They were drilled and production proceeds were paid based on a 2011 quiet title decree. And Oak Creek didn't have their interest vested until June of 18. So there's a very, I think just based on our limited discussion today, we're all struggling with what a pooling order would even look like, what it would mandate Noble to do. That's outside of your jurisdiction. And so Noble's position is that due to the unique title history, in this case, the unique facts, the remedies to the parties are best suited in district court, who has the expertise to issue a remedy that's equitable to both Noble and Oak Creek.
And it's me, tie to what, just a second, sorry, tie to what Commissioner Boygan, I think, brought up as far as a similarity is the district court's position would be to go through all those records, determine when the interest transferred, what value was due to Oak Creek when they actually took title to that interest, and then get sort of all that squared away, and then you would come back here and apply for a pooling application at that point?
Not necessarily. I think, that one of the goals of a pooling order is to have elections and offers to lease made. And I think the district court can fashion a remedy on what that looks like.
Okay, but there might be another reason to pool. It would be for efficient development of the resource or something
That's
along
right.
that line. Okay.
That's correct. But at this point, under these facts, Noble strongly believes that this commission does not have jurisdiction in this matter.
Thank you. Commissioner Jolly.
I think I heard today that Noble suspended the royalty payment in 2016. Is that correct?
I would have to confirm with Noble's
Does
representative.
anybody know that?
I did see
That
that
is
in the
correct.
record.
Then if Noble suspended that royalty in 2016, they must have some idea of what it is.
Noble has offered an accounting to Oak Creek and is not, disputing the fact that it will make an accounting to Oak Creek on what that amount is. It's the remedy that's at issue here. It's whether this commission can force Noble to continue its pooling application and craft an order based on these facts.
Are one of the issues how much the interest is? I'll ask both of you.
Yes, it is an issue.
I disagree. It's not. The interests have already been determined by the district court about who owns what in this subject oil. The only dispute, and let me be clear, what Noble is really saying is they don't think the application of the statute as written, the pooling statute as written, is fair under these circumstances. That doesn't deprive you. The fact that they don't think it's fair or equitable and they don't like the outcome the statute mandates doesn't mean this commission doesn't have jurisdiction to enforce it. Interpreting the pooling statute, applying the pooling statute, and then fashioning a just and fair allocation between parties who have correlative rights in the oil is your job. It's in your sole jurisdiction to do that. And until you do it, nobody can go to court and ask that. The district court has no authority to pool interests or to fashion a remedy to protect the correlative rights of the parties in this situation. They're trying to rewrite the statute because they don't like the outcome. But it's your job to interpret it, and that statute specifically puts it in your hands to do what's just and fair, which is the equitable portion they're arguing about. All we're saying here is you need to go forward and decide that pooling issue. And if you choose not to, if you're going to say today, we agree with Ms. Waslinski that we don't have jurisdiction, you have to be very specific in your findings today as to why you're not exercising jurisdiction and why you don't believe you have it. Or we can't seek relief anywhere, and that's not a good situation for anybody.
Mr. Chair, could I follow up?
Yes, Commissioner Boygan, please do.
So, Ms. Peters, what if Noble had never filed its pooling application? Would you be here in front of us arguing that Noble had to be required to file a pooling application?
I think we probably would have had to file it ourselves if they did not do it voluntarily.
Which you still could do under the statute.
Agreed, and we'd be right back here again, I think, arguing the same issues based on what I'm hearing from Noble, but yes.
And I have another question. If Noble were to agree in open proceedings here and maybe following up in writing that in any subsequent district court lawsuit that's filed by either one of you to determine the rights of the parties, that they would not assert exhaustion of remedies as a defense, would you be satisfied that you could proceed in court?
I think that would be a great step, but I don't think that would solve the issue for the district court. The district court has to determine for itself that it has subject matter jurisdiction, and it will, as we've seen in the prior cases, always defer to this commission to interpret and enforce its statutes before it gets involved.
And if this commission were to rule or to hold today that it either does not have jurisdiction or that this is not an appropriate proceeding for the commission to handle, wouldn't that satisfy the district court?
That's why I keep saying, if you're going to decline to exercise jurisdiction or find that you don't have it, you have to do so very specifically in order to allow us to proceed in district court, yes.
Anything else? Okay, I've heard enough. All right, commissioners, we heard enough. Okay, how would you like to proceed? At this point, we can make a motion if we've heard enough and there's no further discussion or questions from these folks. I believe the next step is we could entertain a motion, whether we agree with the hearing officer's recommendation to allow Noble to withdraw their application or require Noble to essentially deny that, which then I guess would require Noble to go forward with a pooling application. Thank you, Commissioner Overturf.
So I just want to kind of tick through a few things before I make a motion, but I would recommend that we deny Oak Creek's exceptions and that we uphold the hearing officer's decision. And the reason why is because I think that the hearing officer properly applied the relevant law, which the parties agree is the powers test. I think he applied the facts of this case to that legal standard and reached a reasonable conclusion. I also agree with him that there is not a mechanism and that our statutes do not contemplate the commission requiring an applicant to proceed with a pooling application against the applicant's will. I think that's contrary to the process that's established in our statutes and our rules. And so I find that very compelling. One thing that I would just say as an aside is that I find the discussions of jurisdiction and the arguments concerning jurisdiction really puzzling. I think there is no question, of course, this commission has jurisdiction to decide on pooling applications that are before us. This matter does not at all hinge on, and the decision before us does not at all hinge on the existence of the commission's jurisdiction. The commission absolutely has jurisdiction to determine and rule upon applications for pooling that are brought before it. This is simply a question of whether we should allow an applicant to withdraw an application, which to me is separate and incredibly distinct from whether or not we have jurisdiction to rule on an application that would ultimately proceed. So for all of those reasons, I would recommend, as I said, that we uphold the hearing officer's recommended decision, deny the exceptions, and not address the issue of jurisdiction, because I think those arguments are irrelevant to the matter to the decision point that's before us.
I was waiting for the motion to follow, but I guess Commissioner Boygan.
Well, I'm happy. Do you want to make the motion?
I would move that we deny Oak Creek's exceptions.
I'll second it, but I would like to say why.
Okay, if I could actually, just a moment. Because if you look at the order, it says Noble's motion to withdraw is granted. Nothing to do. Okay. All right. I was confused. Okay. Thank you. All right. Go ahead.
Thank you, Mr. Chair. In my view, this is a garden variety title dispute that is common in the oil and gas industry. I would venture to say there are thousands of disputes like this that have been filed in courts and resolved over the decades in oil and gas. There are questions here about entitlement to proceeds, how proceeds were paid, whether parties misrepresented things, when certain parties acquired interests, and the court has resolved some of the ownership issues, but there are still issues that remain over how proceeds were paid in the past, and whether parties perhaps received monies they shouldn't have received, and who's liable and all of that. Courts have been handling those kinds of disputes for generations in this country. There is nothing in our statutes that supersedes that. The pooling statute has nothing to do with those kinds of disputes. And I think, with all respect, that Oak Creek's position misconceives the purpose of the pooling statute. It's not some sort of uber authority to determine rights of the parties to oil and gas. It's got a much narrower focus and is really intended to allow wells to be drilled by assuring that parties who have interests in the area that will be drained by those wells have the right to participate in those wells, or if they don't want to participate, to receive fair compensation. That's what correlative rights is. It is not the function of this commission to determine title disputes between parties. The pooling process was not intended to do that. And so even if this pooling proceeding had gone forward, that ultimately, that issue would not have been decided. This commission would not have been deciding who owns what, who's entitled to proceeds. It would have simply said, okay, we pool the interests in these areas. Now you guys all go determine what that means and who's entitled to what. And so I think that it's unfortunate that this pooling application was filed. I think it created an unnecessary detour and complication in this whole process. I think the parties need to go back to court and fight over who's entitled to what monies. There is no exhaustion of remedies issue here. I agree with Commissioner Overturf. It's not a jurisdictional issue. Pooling is just irrelevant, in my view, to resolving the issues that really exist between the parties. And this commission does not have authority to resolve those issues. Historically has not done so. And so I certainly think the hearing officer was well advised to recommend allowing Noble to withdraw. And I would just say, go to court.
Is there a second to that motion?
I already seconded it.
Yeah, you're.
I didn't, sorry, I missed that. And could you repeat the motion again, please? Just to make sure.
Motion is to deny Oak Creek's exceptions.
Very well, motion and second. Any additional discussion?
Here.
Yes, Commissioner Hawkins.
I'm hesitant to step into this because I'm not an attorney, but from my perspective as a commissioner, I am sympathetic with Oak Creek. If you have an interest in this spacing unit or in this well, you deserve to be paid. However, for the reasons that have been put forward by the other commissioners, I agree with them that we're not the appropriate body to seek remedy. And I agree with the decision of the hearing officer to allow the applicant to withdraw their application and not force them to proceed with an application they don't desire to. So I'm going to support the motion.
Mr. Jolly?
I don't think we can force the application forward, so I would support this hearing officer's recommendation.
Mr. Hager?
I don't have anything to add to what's already been stated, but I'll support the hearing officer's recommendation.
What Commissioner Hager said. Shall we vote? All right, all in favor say aye.
Aye.
Opposed, same sign. Motion carries. I gather that because the exception was denied, then it's automatic that the motion to withdraw is granted.
Yes.
All right. Thank you very much. Thank you all for your time.
Thank you.
Yes, Ms. Larson.
I was just going to say, as you prepare to transition into the next matter before you, which is staff's presentation on the Battlement Mesa BMC pad, Commissioner Gibbs is actually going to be calling in for this portion of the hearing. So Acting Director Robbins has just informed him that this is the time to call in. So if we could give him a minute or two to get on the phone.
Certainly.
Thank you.
I got 2 copies of this. Mr. Gibbs? Couldn't tell us. Did we hear somebody? No, it's an open line, but no one's connected. Is the volume turned up enough?
This was interesting. Part of that, and of course, I think they were for. No. Well, one guy, I don't know if it was a geologist or.
Thank you. Thank you.
I understand that Commissioner Gibbs is on the line, so whenever you're ready to proceed.
All right. So, yeah, we just couldn't hear.
No, that's fine.
Okay. All right. Very well. So how would we like to proceed? Mr. Duranlo, are you going to make a presentation here, or Mr. Robbins, you're going to set this up?
Yes, thank you, Chairman. What we've done today, and staff worked feverishly last night, and I appreciate the work they did. We heard after the public comment yesterday from the commission or commissioners that they desired to get a presentation about the URSA APAD, because that would then allow you to be informed about the request from the neighbors and citizens that you actually think about holding a hearing on the Form 2. We learned that you didn't, you don't have enough information. And so what we've done is we've put together a presentation to provide to you a short introduction to the Form 2A. And that would then give you the opportunity to determine whether you want to take any action on it. At this point, the Form 2A has been approved. The Form 2s associated with this well site have not been approved. And it would be at your discretion whether you decide to do anything further with it. I note from looking in the room that there are representatives from both sides here. At least from the director's perspective, I don't know that it's appropriate that we have them come testify or provide a hearing, et cetera, at this point. Obviously, if the commissioners have questions, they're in the room, and that would be at your prerogative. So with that, I'll turn it over to Mr. How do you spell your last? How do you say your last name, Greg?
Duranlo.
Duranlo. Okay.
Thank you. Chairman Benton, commissioners, thank you for inviting staff to present on this matter. I will go through, I have a fairly lengthy presentation with a lot of pictures because I understood you want to get a feel for, sort of the site and setting of the site out there. I will go through as fast as I can and then invite you to ask questions and draw me back to slides if you'd like. Before I really dive into it, just wanted to make a couple of points. One, as Jeff mentioned, the Form 2A oil and gas location assessment for the URSA BMC APAD has been approved. And the parties who have appealed to you to suspend the approval of that pad also did go through the local government channel for that, as provided for in our rules. Our rules allow 3 parties to seek a hearing on a approved 2 or 2A, and that's the surface owner, the operator, or the relevant local government. And the local government considered their request and did decline to file an appeal to us. So I'm going to go through an overview of the site. Like I said, it'll be heavy with images. Then I'll go into the detail of the pad. I'll show some other photos of the pad. talk about the timeline of the application, and then address some of the concerns that were raised in the appeal letter. Here's the vicinity of Battlement Mesa, and just a general timeline of development in and around Battlement Mesa. In the 1982 Garfield County resolution, a total of 14 well pads were proposed within the Battlement Mesa PUD, which is outlined here. By 2012, Antero Resources, who was URSA's predecessor, had reduced the number of pads and associated infrastructure from 14 to 10. Since then, URSA has reduced the number of proposed well pads within the Battlement Mesa PUD to 5 and potentially 4 as part of their phase development. Phase 1 included, find my mouse here, the BMC D pad and the BMC B pad, both of which were approved by the commission and by Garfield County in 2016. Both of these pads have been constructed, drilled, and completed and are on production. Phase 2 includes the BMC A pad, the BMC L pad, and the BMC F pad, which is a temporary water storage and water management facility. You'll also notice that just on the margins of the BMC, of the Battlement Mesa PUD outline, are several other locations. And here, this slide shows the bottom hole locations from all those pads, and you'll see that some of the pads within the Battlement Mesa PUD target minerals outside the PUD, and some of the pads outside the PUD target minerals inside the PUD. So I wanted to point out some significant features around the BMC A pad. Primarily the Battlement Mesa Metropolitan District public water supply infrastructure, public water supply raw water intake in the Colorado River, pump station, which takes water up to the water treatment plant, the raw water reservoir, and then the water is piped up to the community it goes through a chlorine contactor building before it gets distributed. Also, the wastewater treatment plant is situated right here with settling ponds and another chlorine contactor for the outfall of that, and then the wastewater treatment plant outfall to the Colorado River here. Significantly, the wastewater treatment plant sits between the BMC A pad and any other freshwater facilities. Also of note is the Tamarisk Village Mobile Home Park, the closest neighborhood to the BMC A pad, and Underwood Elementary School. This feature right here is a skate park, and you can faintly see the outline of some ball fields here. This area is topographically higher, and you'll see some slides to show this later, than the area where the A pad is. It's about a 90-foot elevation difference.
Sorry, a quick question, Mr. Drondle. It looks like the BMC A pad is actually south of the wastewater plant, but it's sort of between the outfall, and the freshwater facility is north of that. I thought you mentioned, you said that the pad was between the wastewater and the freshwater.
I may have just been speaking too fast. The wastewater treatment plant is between the BMC A pad and the public water supply raw water plant and facilities.
Can I ask a question? Or are we waiting?
No, go ahead, Commissioner Hager.
So what is the source of the fresh water?
The fresh water is the intake for the PWS is here on the Colorado River. It's Colorado River water. BMC B pad, when we considered that pad, we were looking at the 317B public water supply area rules because of its proximity to that intake. This drawing from the application materials just show the various buffers around the location. The blue buffer is 1,000 feet from the production facilities, the wells and production facilities. So just that gives us an idea of the buffer zone exception zone criteria. The red outline is what we would use to determine whether or not a pad is in an urban mitigation area. So we're looking at 1,000 feet from the boundaries of the oil and gas location. This figure, while rather busy, also from the application material, depicts the distances to cultural features. These distances are also shown on the Form 2A. In this case, we see that the wells and production facilities of the final approved location are both greater than 500 feet from the nearest residence, although the production facility here is less than 200 feet from a building. And therefore, when COGCC approved this pad, we also approved a variance to Rule 603A1. And I'll get to this again in a minute, but it should also be noted that the production equipment configuration was changed on this location. The original proposal had production facility located less than 500 feet to the nearest building unit and a well less than 500 feet to a nearest building unit. And that would have required either waivers from those building unit owners or a variance from Rule 604A1AI. This is intentionally wonky. I wanted to keep the orientation of the pad going north, but this just is the facility layout drawing showing all of the production facilities on the pad: 25 wells, 24 separators, condensate tanks, water tanks, etc. Construction layout drawing, again from the application materials, shows the 27-foot cut at the south edge of the pad, significant cut, and 22 feet of fill on the north edge of the pad. These are the location photos submitted with the application materials. They're drone images, so they're taken from above ground level, and you can see that there was a fisheye lens, which makes the orientation a little bit weird. But you can see that the pad is shown here with the wastewater treatment facilities. This is the raw water pond up here, and the raw water treatment plant is north of that. Turning around and looking to the south, you face right into the bluff there. And then again, the pad looks distorted because of the foreshortening and fisheye of the drone imagery, but looking east and west across the pad, again, you can see that vertical relief. This may or may not show things better, but again, this is just from Google Earth. And just shows the outline of the pad with the bluff neighborhood to the south. So this is looking from north to south. As far as the timeline goes, this application dates back to January of 2017 when URSA sent their notice of intent to construct a large UMA facility to Garfield County and the Battlement Mesa Land Investments, who is the surface owner. Garfield County accepted URSA's offer to consult in February, and the first of a number of on-sites were held in late February 2017. URSA sent notices to the proximate local government, which would have been the town of Parachute, in March, and ultimately submitted their Form 2A to the COGCC in June of 2017. More consultations with CDPHE occurred in August. CDPHE issued their consultation letter to COGCC on August 23rd. Additional on-sites in September of 2017. And on October 27th of 2017, COGCC actually rejected, through our rejection policy, the Form 2A. And it was because, as I mentioned, the original production facility layout had those tanks and separators less than 500 feet from the nearest building unit. And so within an urban mitigation area and an exception zone, waivers would be required from those building unit owners, and they were not all present. Additional on-sites, this slide sort of is all Garfield County process. Additional on-sites were conducted, several public meetings were held, and ultimately on November 16th, 2017, the Garfield County Board of County Commissioners passed resolutions that would approve the three oil and gas locations, which were BMC A, BMC L, BMC F, 1 injection well, and 2 pipeline segments. This doesn't actually approve, my understanding of the process is it doesn't actually approve their applications, but it's a resolution that when their applications land, they will go forward. For COGCC's purposes, we considered this as an agreement on siting for a large UMA facility. In December, URSA resubmitted their applications with not with the reconfigured site and not with all the waivers, but instead with a variance request from that Rule 604 A1 AI. Following that submittal, URSA redesigned the pad, reconfigured it, and moved those production facilities to the north or northwest edge of the pad. And then all of the facilities and wells were then located outside that exception zone. As I mentioned, when I showed the distances, that meant that their production facilities were less than 200 feet from that nearby building, the chlorine contactor building. They did talk with Battlement Mesa Metropolitan District and got a waiver secured from that building owner for that variance. Because of the change at that time, COGCC announced that reconfiguration and reopened the public comment period. And then, as I mentioned, on January 10th, 2019, the Form 2A was approved. So what happened in the 9 months between April and January? COGCC reviewed over 300 comments. 78 were unique and 248 were a representation of a form letter, some variation of a form letter. Those comments were obtained over 3 separate comment periods for this pad. COGCC reviewed the 16 BMPs, negotiated details with URSA, and developed 5 unique COAs. The BMPs and the COAs are all multi-part enforceable requirements on the permit, and they address many issues which were identified in COGCC's technical review and in public comments and consultations. COGCC also adopted many of the Garfield County permit requirements in accordance with our standard practices for such. So they had to meet our thresholds for attaching on the permit. So going into some of the issues that have been raised to your attention, the first was the requirement for an alternatives analysis or an alternative site analysis. And to be clear, COGCC rules don't define, and we have not developed formal guidance for what would be contained in an alternative site analysis. Our rules do require that an applicant for a large UMA facility site provide the local government a description of other sites considered. But the COGCC record does not show and does not require an actual alternative site analysis as part of our record. The local government would evaluate the potential alternatives as part of their effort to reach part of their consultation process, whether they're going to reach an agreement on the location or not. Rule 604C4 requires large urban mitigation area sites to be as far as possible from building units. And so, it is part of our job to review those and determine whether or not the site meets that criteria. So we look at the siting rationale that the operator provided. And then we also consider the fact that the local government did review sites and determine that this was an agreeable site. So, though they're not spelled out explicitly in our record, COGCC is aware that, for example, this site up here next to the high school was considered. It was the Lacey Park site. It was submitted briefly and withdrawn by the operator. This site here, next to the skate park and very close to this same residential area, was originally contemplated in the Battlement Mesa PUD from 1982 and later. URSA also looked at the ability to use land over here and didn't have the relationship with the surface owner to allow it, and would have been limited at the number of bottom holes they could have reached due to technical considerations. The citizens groups brought up health studies that were brought to our attention, and COGCC is aware of numerous studies concerning health issues and health effects around oil and gas. So, you know, the health study that was cited stated that, you know, emissions and pollutants from the nearby facilities, you know, could be a health hazard. Well, COGCC required emission reduction practices above and beyond rules as we considered this this application. So green completion practices, including vapor and emission and odor management during flowback, and immediate connection to sales line or shut in the wells. Extended time on site for the emission controls during flowback. So they're not just removed immediately from the site. Emission controls on all permanent condensate and produced water storage tanks. Enhanced monitoring requirements, including the leak detection and repair. That's LDAR. High combustion, low noise, low visibility emission control devices and flares for VOC reductions is necessary. So that would support those, you know, the flowback emission controls, the tank emission controls, and all of that. And then electric or solar powered permanent production equipment. COGCC, or excuse me, CDPHE consultation supported these specific measures that were addressed on the permit. So, I mean, there's specific COAs in the permits and BMPs in the permits that go into greater detail on those. The issue of the engineering and geotechnical analysis. So COGCC is allowed to place technically feasible, economically practicable conditions of approval on a permit as we review it. We did identify this, you know, the issue of the steep cut bank as a concern. And we did add a condition of approval requiring an engineer's analysis and design drawing for the cut slope and the fill slope, since the production facilities are now going to be placed on fill. We did not require nor review that material prior to our passing of the Form 2A, because our rules really don't support withholding the approval of an application until we get that. The local government permitting process will require, as part of the building permit process, will require those engineered design drawings, and the local government is really the right entity to be reviewing and approving those. So it's important to us that it's required that the site be engineered properly and that we see evidence of that, and then any changes to that get recorded in an as-built as well. Concerns were raised about the injection well location, and based on the topography, the injection well is located at the low end of the Versa's development project, allowing for low pressure drainage to the injection facilities. So water doesn't have to be piped and pumped, or doesn't have to be pumped to various locations. The use of a full injection well and piping network reduces truck traffic on the road, takes water hauling trucks off of the roads, which is important in that Battlement Mesa community. And originally that well the injection well was proposed on the BMC B pad. Because of the proximity to the public water supply intake, it seemed not appropriate. And when there's flexibility in that location, it seemed more appropriate to move it. And so moving it to the A pad kept it down at the low topographic end of the development. And the surface owner and local governments do have significant discretion on where injection well facilities are placed, because they're not a mineral right. It's a surface right to use property for injection purposes. The last consideration in the material that was sent out yesterday to you was an environmental justice. And other than addressing it in looking at 2 potential sites, all I can say is that the alternative locations that were looked at would also have significant intrusion to their neighbors. Proximity to the high school would affect numerous parties, and also the former BMC iPad, I believe it was labeled, would be much closer to those same Tamarisk Farms residents and also closer to the elementary school. As I said, I tried to go through that quickly so that I can invite your questions, and if you'd like me to return to any slides, I can.
Commissioners. Commissioner Overturf.
This isn't a question so much as just a comment that I wanted to just thank Mr. Dronlow and also all of the staff for pulling this amount of information together in order to provide us with this presentation on such a short time frame. I know this was not an insignificant amount of work, and so I really appreciate, and I think there's a lot of value to the public in having an opportunity to walk through staff's thinking on this matter. So I just wanted to say thank you before we got into the questions.
Well, thank you. I appreciate that. And John Noto, Dave Cabesco were very helpful in grabbing the information and putting it together. So thank you for acknowledging that.
Yes, I think they're what she said. Commissioner Egger.
Do you know in general the depths of the formations that are being targeted by these wells? How much deeper from the surface that the target formations are?
I don't have that information at my fingertips. Obviously, the APDs are available and have that. Stuart Ellsworth, our engineering manager, might have it at his fingertips.
So, and Stuart, when you do that, would be probably if you can provide the depths to the top and the bottom of the completed interval of true vertical depth, if you happen to have that. So measure depth since they're directional wells.
I have measured depth, and the reaches are somewhat significant, but it still gives a pretty good perspective in that the measured depth is at 6,800. Vertical depth.
That's to the top of the formation?
I don't have that. I have to look that up.
Okay.
But as far as the depth of the hole, vertical depth, you're looking at about 6,000.
And these are all Williams Fork completions?
Williams Fork formation.
So notionally a couple thousand feet maybe?
Yes.
So your top would be 4,800, 4,500 plus or minus somewhere in there?
Yes.
Okay.
Yeah, you're on scale.
Okay.
Chair Benton, Ms. Stanzik also, she went to get further information to help address that.
I think that would help to at least, because I think the TD is total depth is beneficial, but I think it's more of a concern of where's the top.
I mean, I can look it up real quick.
Yeah, and also it might be beneficial to look at how the casing and cement program, like they have to bring cement all the way back to surface, depth of surface casing, some of the basic generic things related to the wells. In general, yeah. And maybe I'm going too far, Commissioner Eggers. Would that be helpful to you, or did you just want to look?
Yeah, that's more detail than I need, but that's okay. You can get it. You
I mean,
have more
I'm pretty familiar with
expertise on
this
that stuff.
area, but if it's, so we don't need it if you don't need it.
Well, the exercise I'm doing is going into how anyone would want to look at it in the public. So you can dive in and look. And these are all the permits in Garfield County. And if we, 2A permits, so if we slide down to so if we click on the permit right here, this is one of them. And we can look at the PDF or the attachments. And this will be a PDF image of the permit eventually. And we could slide down to the casing design. And so we have a conductor casing. This is a conductor casing is steel that's placed in the ground at 60 feet. It really is to stabilize the surface. And then we put the surface casing. Again, this is slightly deviated at the surface, so they'll get a little bit of a slant. So that's roughly speaking. And these are all measured depths. So we're looking at the measured depth of that hole. And based on that kind of volume of cement, they're going to come very close to the surface. So pretty well cemented. Now, and it is, let's see, I went too far. So we should have up here. So the total measured depth is 68. Williams Fork. So what I'm going to do now is to get an idea of the vertical depth. I'm going to go in and look for a hole. I'm going to go to the GIS map. And this will take us right there. And so what I want to do is to give an idea of what you're asking. I'm going to go to a well. So we're right here. So I'm going to go to a well that's nearby where I can look at the more details to get that vertical depth. So again, here, this well was proposed to be 7,000. So it's kind of in range. So we have a total vertical depth of 6,000 and a measured depth of 6,800 on that. If we look at the top of the Williams Fork, you're at 3,400. And so that gives you a pretty rough idea of the scale.
Can you go back to the GIS map? Because one of my other questions was how many existing wells are fairly nearby?
Well,
and so our the red dots are wells. What's the yellow?
Well, it's the status of the well. So here, so right there, this gives the various statuses of the wells. So you can see the yellow dots, and because these are multi-well pads.
Yeah, put on the direction.
Well, yeah, because these are multi-well pads and directionals, you can see that it's in a network. This is roughly speaking 10-acre spacing. So that's why you're seeing numerous wells. Again, this is what we're looking at. So let me try to zoom in.
You know, I've got a slide that shows shows those, and it might be easier just to pull back to that slide. Sorry.
And do you know, are those wells older or more recent? Looks
So
like they're horizontals.
these here, they're all S-curve directionals, so they're vertically inclined in the producing formation. The BMC B pad and D pad wells, and the well that Stuart clicked on was a B pad well, or the most recently drilled in that area. Monument Ridge was earlier, as well as the Watson Ranch pad wells were earlier. These wells up here have not been drilled yet. And then the B and V pad across the river were also recently drilled and completed.
Okay.
The color coding here is the purple are wells that have been completed. The green are wells that are permitted, not yet drilled. And the cyan, light blue, is wells under review.
Okay, thanks. And can you tell me a little, the injection well, it's going to be on pad. And that is, how is that permitted? It's just included on the Form 2A for this well pad?
So the injection well itself is part of the production facility package that is reviewed from the surface perspective on the Form 2A. The injection well is also subject to a Form 2 APD, application for permit to drill. It's also subject to a Form 31 and 33, which actually approve the injection process and the injection formation. And Stuart could talk in more detail about that. But yeah, it does require, the same surface review as any other facility.
And that's been submitted already?
Their Form 2, their APD has definitely been submitted.
In a way, it's kind of a two-step process. The Form 2 and 2A are our review, and that is the surface relationships that Greg and John look at for the oil and gas location. And then the 2 is a drilling permit, which allows us to register the well. And then a key distinction that is that injection is actually an EPA approval. And that's our Form 31 and 33. I like to think of the 31, though we call it an underground facility, what we're really permitting is an underground vessel. So it's the formation or the porosity underground. And because that's an injection process, that is a part of the, let's get a little backwards, the Safe Drinking Water Act. And so EPA has delegated that authority to us for them to approve injection permits. And we have Class 2 authority, which is related to oil and gas, disposal of oil and gas exploration, production waste, which is mostly produced water. And we also deal with enhanced recovery, which is another topic.
And
But
how deep is the injection well going to
It
be?
is in the Cosette Corcoran, which is just, it's a part of the Isles Formation, which is under the Mesa, the Williams Fork Formation.
Okay, thanks. And then the last one's not, maybe Stuart won't agree, but the last one's not so easy. I just want to go back to this cumulative effects. And it's something that the citizens brought up, and you addressed it on your slide. But cumulative effects are hard, right, to look at. And what we can do is we still kind of take them individually and say, here's how we'll address each one. And I'm just curious and maybe looking for any input that you, or maybe you had discussions with CDPHE on, is that the best way to measure or to address cumulative effects? Because I think probably what citizens are looking for is, it's the light on top of the noise, on top of the odors. Mm-hmm. And I'm not sure there's a way to look at that, and just want kind of your comment on that.
So I think you've characterized it correctly in that we really look at individual potential impacts and address them from an individual perspective. Your characterization of cumulative impacts are still somewhat individual in that you're talking about the noise, light, odors, dust, maybe traffic from one site. Whereas I think some would characterize cumulative effects as, hey, this is the 11th pad, or, and so I guess from what perspective can you really address that? And it does boil down to the mechanism that we have to address that is by looking at the individual potential impacts and striving to avoid impacts where possible, minimize them where we can't, and then mitigate the ones that we, that are just unavoidable.
Right. Okay, that's all I have right now. Thank you.
Following on with that, with the cumulative effects, because most of the disturbance is going to occur during the drilling and completion operations. So was there some thought put to, when you look at the B and the D pad have already been developed, now we're going to come and do the A pad, that these are done rather than concurrently, done sequentially, so that you don't have quite as much cumulative noise going on, say within that a 5 mile area around there. So you got only one drilling rig running as opposed to 2 or 3, and one frac fleet running.
Yeah, I mean, I think that was definitely a consideration while the B and D pad, phase 1 of this occupation, if you will, was underway. And, they started on one pad with the drill rig, moved up to the other pad, fracked the first pad, switched them. So they were both, they were trying to do two things. They're trying to minimize the overall time that they're there, and then also, minimize, don't bring 2 drill rigs in and 2 frac fleets in. So it is to some degree a balancing act. I think having, the phased approach to the development makes sense. And I think some of that is really in the hands of the beholder too. So, what may make sense to me in my world, someone else might feel differently. So
yeah.
I think that's a challenge.
Fair enough. Thank you.
Mr. Chairman?
Yes, Commissioner Gibbs.
If I can I weigh in?
Of course, you're one of the commissioners.
Okay, great. Thank you so much. And I wish I could be there. I'm over in Westminster for water meetings, but I appreciate the staff presentation, and I'm doing my best to listen in. So it's always hard to call in, as you know, because I feel like I miss bits and pieces here and there. So I apologize if you've already addressed this, but I'm just looking at it. It appears that URSA provided a siting rationale as opposed to an alternative siting analysis, and staff mentioned how there was some local government alternative siting analysis done, I believe, but was that done by URSA as well? I just want to hear more clarification in terms of what alternative siting analysis has been done.
Sure, and thank you, Mr. Gibbs, for the question. So I'm going to try and get to the right slide here because I've got the rule citation written out. Here we go. Oops. So Rule 305A-B2 requires an applicant for a large UMA facility site to provide to the local government with their, what we'll call the 90-day notice, their notice of intent to construct a large urban mitigation area facility, a description of the other sites considered and why they didn't choose those other sites. It doesn't specify that those sites need to be outside of a UMA. It doesn't specify what criteria need to be used to make that consideration. So that goes directly to the local government. And then, along with this invitation to consult. And so, in this case, Garfield County formally accepted the invitation to consult and commenced the process. Ultimately, the Garfield County agreed that this was an appropriate location for this facility, and that was taken into consideration in our approval. So, the sites that I show on the screen right now as sort of alternative locations, these are sites that we know were considered based on history. So COGCC staff is relying on our, intrinsic knowledge to the site and the setting as well. And I mentioned that there was sites considered over here as well. Those were actually considered as an alternative location in the brief period of time that the Lacey Park pad was under consideration. So, I guess that's where our review, our technical review, has to just be carried out on that. It's not a matter of reading their alternative site analysis. Hopefully that got at your question.
Yeah, and if I could just follow up. So if the local government, in this case, Garfield County commissioners or staff, under this, information consult process, raise red flags and say, hey, what about these alternative sites we move forward? Then is it historical where COGCC staff would say, okay, we'll then, approve these or look at these other alternative locations or?
Director Gibbs, this is Jeff Robbins. Let me take a stab at that, knowing that I've only been here for about a week and a half, but I've talked with staff about this location. And as best I can tell, and I reviewed the file extensively last night as well, the staff's current sort of approach is they use the 305 consult that the rules direct the operator to consult with the local government when it's a facility that is this close to residences and there's over 8 wells involved. And I think, and Greg, correct me if I'm wrong, but where Garfield County as a local government agreed that this location was acceptable, the COGCC staff did not undertake further alternate site analysis, given that that was what was done. Because as I looked into the file, what I sort of saw was a siting rationale. It was like, this site works, and that's in our file, but I didn't see specific alternate site location analysis in the file. I think what Greg was speaking to is he was aware that that took place with the consult between the local government and the operator in this case. Did I get that right, wrong, or otherwise, Greg?
Yeah, no, and I think you're on the right track. I mean, if the operator came to us and did not have agreement from the local government, then certainly I think it would be absolutely appropriate to say, well, what were the other sites that you considered and why aren't you using them, especially if the local government has a preferred option? In this case, you're right. The siting rationale was more of a justification document, although the reach analysis was covered and why they can't be 2 miles away. I'm being fed some rule information. And so, yeah, and again, if the agreement is not reached with the local government, the other thing that happens then is it'll get noticed for a hearing before this body. So, that agreement is significant.
And just to follow up, this is Director Robbins again. That's kind of why you had received from the neighbors a letter before the hearing yesterday and then a letter last night, both of which sort of focused in on this alternate site analysis as an issue. And so that's sort of what is before you in terms of whether you believe what we have in our record is adequate or whether you desire to, see more, have a hearing, or whatever it may be.
Commissioner Hawkins.
Just like to add a little. I know I participated in the rulemaking when this was discussed, and my recollection was that we were trying to allow a more input from the local government regarding locations that were going to impact their constituents. And so the language that's put in is for the operator to provide alternative siting analysis with the local government, and if that's acceptable, if the site that's chosen is acceptable to the local government, then it was going to be acceptable to us most likely. And if it's not acceptable to the local government, the local government and the operator could come to the commission for a hearing. So that's reiterating what you've already said, but I do think it was an attempt to give a little more consideration to the local government's concerns as opposed to the commission just dictating what we thought was best.
Commissioner Gibbs.
Yeah, thank you. Let's see, I was just going to say, so if we decided to have the full commission hear this, this would provide, URSA an opportunity to really get those alternative siting analysis, to us, right? That we don't currently have.
Well,
Yeah.
I think I would characterize it more as that analysis was performed in cooperation and collaboration with the local government, which is where we designed these rules to get to, which was that once the local government basically has primacy over that initial process, and that our expectation is the operator works with the local government because they're the ones that have to deal with the surface impact. And if the local government reaches an agreement after going through a collaborative work with the parties that are involved, and they come up and we all agree on that, then it comes to the COGCC and says, yeah, we've all shaken hands over this and let's proceed, that this is the most reasonable place to develop. If that did not occur and there was not agreement with those parties, then it would come to us and we would get more detail around what the operator said, well, we've analyzed these sites, this is why we can't go to those. Is that, I mean, that's the way I was in that rulemaking also, and that's the way I was left with that. So is that the way you see it also, Mr. Tronlow?
Yes, sir.
Okay. Mr. Overturf.
Yeah, thanks.
Okay, go ahead. Sorry, Commissioner Gibbs.
Yeah, thanks for that clarification. Do we know what the local government process looks like? Are there, hearings where the public can show up to county commissioner meetings to state whether they like this or they don't, or what does that local government consult process look like?
Mr. Dronlow is prepared to answer that.
So yeah, the Garfield County process, and I will speak to that exclusively, was extensive, had numerous public meetings, and also, I believe, even had an on-site with public invited, which I would say is fairly unusual. They do, it's a planning process, planning review process. So there's public hearings, as well as informational meetings. So this slide that I've got up now shows, just sort of the last bit of it in November of 2017. But I mean, Garfield County's started reviewing it, from a technical perspective as soon as they received the application in January of 2017. So there was plenty of opportunity for public input into that process.
Commissioner Gibbs, I don't know if you have access to the slides, but would it help to have Mr. Dronlow go through a few of the dates and what took place?
Yeah, you could email that to me, dan.gibbs@state.co.us.
Okay. But what it looks like here is that the process started in January of 17. February 17 was when Garfield County first accepted URSA's offer to consult. And then there were several meetings held in November, one of which included, and it continued on throughout the summer. And then in November, there was a public meeting held at the Battlement Mesa Activity Center in November. Another public meeting, that was November 14th, another one November 16th, November 9th, there was a public on-site. And finally, 11/16 was when the locations were approved by Garfield County commissioners. So it would appear to be fairly extensive.
Thank you for going through my slides. No, I appreciate it.
Yeah.
Yeah, I mean, and that is sort of the external facing portion of it. obviously Garfield County staff was also reviewing things on their end too, to be informed and prepared for those meetings.
If I could add just
I think Commissioner, let's check with Commissioner Overturf first because she was waiting patiently.
I wasn't here when those rules were adopted, obviously. But I understand the intent behind them. And I think it reflects my understanding of some of those prior rulemakings, which was really to kind of designate local governments as the entity through which the public was provided an opportunity to engage in a lot of these discussions. And I think that was a really laudable focus of that rulemaking that occurred. Was it 10 years ago now? 8?
No.
2 or 3 years.
It was only about 2 or 3 years ago that
Okay.
we did this.
Oh, because it was after the task force.
Right. It came right after the governor's task force, and that part of that rulemaking was the result of the task force. We were charged to do certain things.
Right.
One of which was to address development in areas where there was a fair amount of urban development.
Right. So, so recognizing that that was the intent of that rule, I'm nonetheless struck with the way that it seems to be interpreted as providing the sole forum in which that conversation happens, and just in some ways sort of delegating that analysis of alternatives solely to the local government. And I think there's an important role for the commission to perhaps retain in having the ability, perhaps not the requirement, but an ability to ask for alternative site analyses, even if the local government is like, we're cool. Just because it seems as though there's perhaps a value in having that ability that the staff, if they feel like in response to public comment, they think it's valuable to require that kind of an analysis, that they would have the ability to do that, which does not seem to be the way that the rules are currently being interpreted. And I will admit you have spent far more time with the rules than I have, and so have a better understanding of them. So that's just one thing that I note cannot be solved here as part of this conversation, but is just an observation as someone who has is somewhat newer to this process. The other thing that I wanted to say, and I would love to have feedback from other Esquires about this, but I am struggling with, in response to Commissioner Gibbs's question about sort of what could we look at if we were going to have a hearing, the path forward procedurally is not at all clear to me. And I often joke that there are two types of people that went to law school. There's people that like to argue and people that like rules. And I like rules. And I like there to be a process that we go through and then we figure out what we're doing. And I don't know what the process is here. I've looked through our rules. It appears to me that the decision approving the permits, because it was not challenged by the 3 entities that are granted standing under our rules, because that challenge did not occur within 10 days, it appears to me that the decision approving the permit is a final decision of this commission. And so I'm not clear whether we can even, I'm not clear what options are on the table for us under the existing rules in terms of having an additional conversation about the details of this process. But I also think this is a really instructive case that we may be able to take some learnings from in the next rulemaking, whenever that may occur. I have a feeling there might be some rulemakings that are going to be happening in our near future. The end.
This is Director Robinson. I appreciate that procedurally we're in a sort of a, I don't know if you want to call it a no man's land or what, but yes, I think at this point, the decision to approve the well location, the 2A, which was rendered on January 11th, was not subject to an appeal by the local government or the surface owner or operator. And so that decision stands. We had received from the neighbors the request that you consider whether you would like to have a hearing on that Form 2A. Attorney General Davenport and I looked at the rules, and I don't know that you've been lodged with that request before. Certainly new to me in my 7 days here. There is a rule in the 500 series that seems to be kind of a sort of Trump rule that if the commission wants to take action on its own by setting up a hearing, then you can take an action on matters involving this rule book, which this would be that. Mr. A.G. Davenport, did I get that right?
Sure. Yes, you did. It's okay to chime in. I will. It's Rule 502A that provides that the commission may, on its own motion, initiate proceedings on any questions related to anything that has jurisdiction over generally. That's taken from the act itself as well. The commission can act on its own motion. It does require that there be notice and the standard hearing process be followed before the commission conducts such a hearing.
Chair.
Commissioner Egger.
So I'm wondering what the difference is when we allowed Adams County. It was a hearing on a Form 2A approval, right? And we allowed a hearing because Adams County, I feel like they came here. I don't remember if they had documentation, but they said we were the adjacent county and we didn't have standing to participate, and we want to be heard.
And may I respond to that?
Yes, you may. I'm just wondering, Commissioner Hawkins, I haven't forgotten about you if you have something you need to say. So go ahead, Commissioner Hawkins.
My recollection is that occurred, so there was a spacing application that was filed. And as part of that spacing application, Adams County essentially said, hey, wait, you changed the locations that you were talking about and we didn't have an opportunity to participate. And so we feel like we were deprived of our due process. And then we said, okay, we're granting the spacing order today. We know there are going to be 2s and 2As that are coming down the tubes. And so we want to make sure that we have a hearing on those. So the timing, we kind of got out in front of it. Whereas here, this whole process has already been underway.
Okay, thanks.
Very much. Commissioner Hawkins.
Not to backtrack too much, but I do think the location of these facilities is the authority of the commission. And the rulemaking after the governor's task force was to provide more input for our local government to impact decisions on developments in their area. And I think that's what the rules were trying to accommodate. But I think it's ultimately our decision, if we don't agree with where this is headed, that we could review it at a hearing. So I think, we're trying to accommodate the concerns that local government brought to us, that they want more input, they want more control, and in particular with large facilities located close to their constituents, that's what these rules were trying to accommodate. So we're all still learning, I guess, since this was one of the first ones.
Mr. Davenport, you have something to say.
Thank you. There's one other matter that I'd like to bring to the commission's attention, and that is, I know we've had discussions before about Rule 508. I think Rule 508 provides guidance in regard to how I'm going back to the public issues hearing will be convened. And it provides that upon a request or upon the commission's own motion, a public issues hearing may be convened. It sets forward, I'm referring specifically to Rule 508J, it sets forward a decision-making process for this commission. And what it provides is that before the commission starts to consider whether or not it's going to make changes to a permit or an application, it needs to make some preliminary findings. And those are 3 preliminary findings. The first is that the public issues raised reasonably relate to potential significant adverse impacts to public health, safety, and welfare, including the environment, that are within the commission's jurisdiction to remedy. The second decision is that those potential impacts in this case would not be addressed, have not been addressed by the permit. And the third decision to make is that the potential impacts are not adequately addressed by the rules and regulations. So if you choose to conduct a hearing on this particular permit, that would be the process to follow, is to make those 3 preliminary findings first. And essentially that it's an issue that you have jurisdiction over and can remedy, and that it's not addressed by the permit that's been issued or the rules themselves. And once you make those findings, then you can go to a second step where you start to consider whether or not to attach additional things to the permit or something else, if that's helpful.
Mr. Boygan.
Thank you, Mr. Chair. This has been a very interesting discussion. I'm a little puzzled by a few things. One is this public issues hearing that Mr. Davenport alluded to under 508. I think you're alluding to 508J.
Yes.
So I guess I had been under the impression that 508 dealt with applications for public forums on applications for increased density. I wasn't aware that it could be applied to some other issue of public concern, and I'd be interested in further discussion on that point. But really my main question is, if we decide that 502 has some applicability here, 502A, and that the commission wants to initiate some kind of a proceeding, let's say a hearing, it's not clear to me what the ultimate objective would be, other than to give everybody an opportunity to have their say. Would we be potentially requiring an alternative site analysis that could overturn the decision to approve the permit? And can we do that under the rules? I guess I'm just puzzling over process here. If the commission wants to have a hearing to get a more complete picture of what happened here and whether there are issues of concern, I guess that we can do that. I'm just not sure where we would go with it, but I guess we could cross that bridge when we get there.
Mr. Chair, do you mind if I respond to one point, Commissioner?
I do not mind at all. Please proceed.
In regard to your question about Rule 508 and its applicability, where that came from is the fact that Rule 503B6 provides for when a local government with land use authority requests a hearing on an approved application or permit, that hearing will be conducted pursuant to Rule 508 J, K, and L. And so recognizing that that's not what's happened here, that does provide the best guidance for how the commission can. Correct.
Fair enough. Very well.
That's the only thing I'm.
Commissioner Jones.
Wouldn't it also have to be called by somebody with standing or protested? But before you answer that, it seems like you guys are giving the background on how the rules were established, or the spirit in which they were created has worked here. I mean, the Garfield County Commissioners did do a lot of outreach and unanimously approved this. I'm just wondering what the deliberation that we're discussing is coming from. I know that it doesn't make everybody happy, but I don't think you ever are going to on these UMAs. We've seen where there were other sites looked at, so I'm just kind of wondering where this is headed.
Would you care to comment?
Well, I would like to just answer Commissioner Jolly's question in regard to this issue of standing and that no one has requested here. That's true that no one who has been provided standing under Rule 503B6 has requested a hearing. However, our previous discussion about Rule 502A and the opinion that that does give the commission the authority to order a hearing on its own motion, which is what you,
The other one, Jay, but
Yeah.
which is what you'd be doing in this case, Commissioner Jolly.
Yeah.
And you would have to follow all the notice, all the normal notice and hearing procedures as well in doing that.
oh, I would just close with, I do think that we're starting to work against the intent of what I think was being created with having the local ultimate control rest with the county, not this commission.
I'll comment on that, having been part of that rulemaking, which was a relatively long and arduous process to get to where we are, which I think I would say does a reasonable job of addressing it. And I'm a little concerned that there seems to be some thought that perhaps these rules don't cover most of the options. It was very clear that it was to place the initial process in the hands of the local government for where that surface location was going to be if it was in a large urban mitigation area. Commission primarily deals with and works with development subsurface and protecting groundwater, making sure that it's reasonable development, protects correlative rights, prevents waste. We do have to consider equally the environmental impact and impact on health. However, in that rulemaking, it was very important that we provide a larger opportunity for local government to participate and for folks that live there to participate through their local government. I think a concern I have here is that if the local government and Garfield County has been very active. Their LGD has been in place for a long time. They're very active in this. I do have a concern that if we go too far down this path, are we then taking some of that away from the local government? And I will leave it at that. And just to say that it was pretty darn hard to come up with these rules. And obviously, we can always revisit those as we go along, but I think they do a pretty good job of addressing what we need to do for development. Although I am not an Esquire. Right.
And may I just respond to that?
Yes, Commissioner Overturf.
I certainly am not intending through any of my comments to minimize or restrain or constrain the abilities that we have given to local governments to participate in that process. That is not in any way my intention. I think what I'm interested in is there a concurrent process that the COGCC can also recognize? And I guess where I'm sort of focusing is around these alternative location analyses, and how are we ensuring that we truly are minimizing the impacts on nearby residents by looking at all the options that are on the table. And I guess what concerns me here is the reliance on a siting rationale rather than kind of looking at all of the options on the table. Doesn't seem as though maybe overly restrictive, I guess. And so that is my motivation for saying these comments. It's not in any way intended to limit the ways that we have expanded opportunities for participation by local governments.
And my belief was that when we created these, that it was primarily for the purpose to put the experts in to do that assessment. And that it's going to be that the folks that look at where those sites may be and the impact on the folks that live there and the individuals that live in that area is best addressed by the people that live there, which is the local governments. And so I'm concerned that then it does become a duplicative process that we ask for the same thing to be done that the local government's already doing.
it's not clear to me that the local, it seems as though the local government process was robust and open. And I do not doubt that or critique that in any way, but it does not appear that the local government participated or required a proactive alternative site analysis. So I don't think that it would be duplicative, but I may be misunderstanding.
I think they had a pretty robust, if you look at all the dates, it looks to me like it was a pretty robust process.
I recognize that.
And I mean, our reliance has to be on, on the record. The record indicates the agreement. The local government certainly has the ability to not agree to the location based on the alternatives that they see feasible, presumably presented to them by the operator. But if they saw other vacant land that they wanted addressed, that would have been addressed in that process, and that would have come forth in a we don't agree to this pad. So I think going back to, we did want to put that, consideration in the hands of the local governments as early as possible. I mean, if you'll recall, well, some of you will recall, we talked about, the surface use agreements and whether or not, if they have a surface use agreement, is that too late to go to the local government? And all of those considerations. I mean, we really wanted the local government consideration of alternative locations to be very, very early in the process. And I think here it happened.
I think Commissioner Gibbs, you started to say something.
Oh yeah, sorry. I just think, first of all, I'm a local government guy, elected 3 times as a county commissioner, and the Garfield County commissioners are friends of mine that I respect. But, having a hearing would at least allow us to gut check what Garfield County did on, alternative siting. And I know there's, I haven't been able to see the PowerPoint that you all see in front of you. And I apologize for that, but, just being able to, see what they did, I think is important.
Commissioner Jolly?
One point I just want to remind everybody here that's seen the presentation today is we're not discussing 2 or 3 mile underground laterals or horizontal laterals like we usually are over here. So there aren't probably as many potential sites as one might think that we may just be assuming from 99% of what we're looking at over here is, we look out 2 or 3 miles. That's not feasible with this, and for whatever relevance that may have with anybody, I just thought I'd mention that.
I'm also, so if Commissioner Gibbs, prior to doing that hearing, which does take a fair amount of effort and coordination on behalf of staff to do that, would it be reasonable to have a meeting with the Garfield County Commissioners to discuss the process that they went through? And then if we still need additional follow-up, then we could go ahead and go forward with the hearing. At this point, our attorney is. Go ahead. I don't know. We'd have to be more specific, because not sure if that would be a public meeting, how that would be conducted. Okay. Mr. Duranlo.
No,
you're not.
Yeah,
okay.
I'll refrain from saying anything.
Okay, thank you. Yeah, Commissioner Hager.
I just have a comment that the one thing is all we're seeing is just the presentation of how they came to that conclusion. That might not mean just because it feels like a rationale on what they chose doesn't mean that they didn't do alternative site analysis. And I recognize that maybe that's all we're trying to figure out, and we might be able to figure that out in a hearing. But let's say we do figure it out. What are we going to do? We can't say, Garfield County, you did that's wrong. We don't, right? We can't say it. So what do we expect everyone to come tell us? I mean, they probably will come tell us that they did a pretty good job, and maybe we walk away and we feel better about that. But if it's a hearing that requires Garfield County to spend money and time to get here and present it to justify all the power that we gave them, I guess I worry about that a little bit. And I don't know that we can sit up here and judge how they came to that determination.
Well put.
May I respond to that?
Yes, Commissioner Overton.
I agree. I mean, I think that if we were going to have a hearing, the topic of the hearing needs to be something that is, again, as Mr. Davenport said, within our jurisdiction to remedy. I think the sufficiency of Garfield County's process is not our business. We don't have any authority over that, I don't think. So, I mean, I think if we were going to have a hearing, I certainly don't want to have a hearing just for the sake of talking things out. And so I am not convinced that we should have a hearing at all. But I think if we were going to have a hearing, it would need to be about something very specific that we wanted to require as part of our process, such as requiring that the operator conduct an alternative site analysis for our own permitting process. Again, I am not proposing that as my recommendation because I don't know that I'm there, but I think this is probably best dealt with in a future rulemaking. But I want to make sure that it's completely clear that I am not proposing that we require Garfield County to engage in some long process and spend money on something just because.
Mr. Chair.
Yes, Mr. Robbins.
First off, I want to thank you for having this discussion. It's helpful to the new director, acting director, as he navigates the first few days over here. Secondly, I agree. I don't think that this commission is, weighing down into Garfield County's process and what it's doing. Thirdly, though, and I'm new to all this, but as I read the large UMA facility rule, it does say for the acting director, and I wasn't the acting director when this was approved, that the large UMA facilities need to be as far away as possible from buildings. So that is one of your rules. And, I would say that in applying that rule, that staff and I, and then you as commission could make sure that that rule is met. Now, I just sort of say that for purposes of, think about that and give us direction here at the commission about how that's interpreted, because I think what I'm hearing from staff is that the current interpretation has been that we sort of defer to the local government. Obviously, there are times when we're in this place where the citizens feel that that interpretation at the local government level wasn't correct. That's why you're here today. So I don't know, I just throw those three thoughts out there for you.
A brief comment on that. I think it's fairly well characterized, but I also recall that the 2A was originally rejected because the facilities were on, I believe, would have been more or less on the west side of the pad, and staff said, we're not going to accept that because you need to move it to the other side. So staff did participate in moving the facilities as far away from a building as possible, and then in cooperation with the local government to decide on what's the best location. Where I struggle with that, the concept of the alternative site analysis, is that it seems to me that was conducted. We do, I suppose, we have URSA here. We could probably ask them if we wanted to, sort of what they did in this particular case. But someone looked at that and they didn't just dismiss it out of hand and say, oh, well, we looked at these two places and they won't work, so we're going to go to this one. I think based on what I've seen here, there was a lot of work went into deciding where this was going to be sited. Our staff had input into where the facilities were going to be located to keep them as far away from a building as possible. I'm just not sure. I kind of go back to where Commissioner Hager is. If we hold a hearing, what's the expected outcome of that? Other than what we already know and now have been summarized on the effort that went through by the staff to get this put into place.
Mr. Chair, could I just
Yes, Commissioner
footnote?
Morgan.
I wanted to respond to what Director Robbins brought up. The rule says, this is in 604, oh, there's so many subdivisions here. What is it? It's a 3, well, anyway, I'll read it and we'll get the subdivisions later. Anyway, it's subdivision 4. Large UMA facilities should be built as far as possible from existing building units and operated using best available technology to avoid or minimize adverse impacts to adjoining land uses. To achieve this objective, the director will require a combination of best management practices and required mitigation measures, and may also impose site-specific conditions of approval related to operational and technical aspects of a proposed large UMA facility. So the question is, can we as a commission, in the abstract, without even talking about the fact that this 2A was already approved, does this give us the authority to require an alternative site analysis? We had that debate ironically with Mr. Robbins last year when he was representing Adams County.
That wasn't a NUMA.
What?
I don't think that was a NUMA.
It was just outside.
Oh, it's just
Yeah.
outside, although you were arguing that analysis,
I know, and
that rationale ought to be applied. If it should be applied anywhere, it would be with respect to a LUMA, but in any event, I think we kind of debated that, and there isn't any specific language in the rules that talks about an alternative site analysis. You'd have to sort of get there sort of indirectly, not to say that we shouldn't try it if that's what we want to do, or we should maybe engage in a rulemaking to implement it. The question still would be here, what do we do with this permit? And does the commission want to have a hearing to hear all the reasons why this site was approved by the commission, not by Garfield County, and hear the citizens and let them talk about it, and hear URSA and let them explain why citizens' concerns are not appropriate or have been addressed. And then at the end of that, like I said before, decide where are we going with that? It's essentially it's a safety valve hearing, and I'm not sure where we're going with it. But if that's the sense of the commission, and enough commissioners want to do that, great. It's better than hearing disputes over spacing units.
Chairman, may I add a comment?
Certainly. Mr. Dronlo, go ahead.
So I want to make sure that when we do talk about the alternative site analysis, we're all talking about the same thing. And I know that circulated to you was the 15-page comment response document that summarized COGCC's review and review process and the public comments received and how the application as approved addresses those comments. Attached to the Form 2A is a more robust document that is called it's called Siting Rationale and Alternatives Analysis. And I should have been more, I guess, clear earlier. It does mention several pads that were considered. The other thing it does talk about is the overall consideration of the whole suite of bottom holes, and then how the surface locations can be placed to accommodate those various bottom holes. Another pad that I didn't mention was the M pad further north in the Battlement Mesa development. And by utilizing, again, by moving surface holes from one bottom hole, the surface holes to hit one bottom hole, move the surface location from one pad to another, they were able to eliminate an entire pad. And so, I mentioned the Lacey Park pad, the former BMC iPad they actually refer to as the Parks and Rec pad. And I think that document was provided to us. It was provided to Garfield County during their review, and I apologize for not realizing that there may have been a disconnect on the robustness of the documents that you reviewed in preparation for this. I was gonna pull the document number for the record that is, just so that if anybody wants to look for it, they can. And with 41 files attached to the Form 2A, I'm having trouble picking that one right out, and I apologize. I believe it's 4014-88245. And the alternative locations considered starts on page 4 of that document.
May I ask a question of Mr. Drolno?
Yes, you may, Commissioner Overturf.
This may be putting you on the spot, and so if you cannot answer this question, that is fine, and I understand. Let's say that you did not feel, let's say that there was a rule that explicitly said, in assessing any 2A, staff can require the analysis of any alternative site in order to ensure that the development is minimizing impacts on local residents. Is there a site available that you would have wanted to look at that you did not feel you had the opportunity to look at? Or did you feel that staff was able to look at all the alternatives that you would have wanted to see?
I mean, given the considerations of development out there, there are not many locations to look at. And the ones that were considered, the ones that I pointed out, certainly didn't on the face appear substantially or even marginally better than this. The location of this pad next to the wastewater treatment facility, down at the base of a bluff where it'll be shielded from view from the residents above it. I mean, yes, they are close residents, but they're also, that view is obscured. They're not. It's not right up in front of them there. So I do feel that this location makes a lot of sense for a lot of reasons.
So it seems to me that if we were to have a hearing, that the remedy that we would be kind of moving toward would be empowering staff to require the analysis of other alternative sites. If there are no other alternative sites that staff feels it was prohibited from analyzing, then I'm not sure that it makes sense to go through that process for a hearing on this issue, which is the issue that's kind of most compelling to me. But I would say that it would be, Mr. Robbins, to your point earlier, that in terms of direction, that it would certainly be my hope that staff would feel empowered to be able to ask for the evaluation of any alternative site that you thought was worth looking at. And if you do not feel that you have that ability under the existing rules, then I would be interested in understanding how we can change the rules to provide you with any additional authority you may need to require a hard look at other alternatives. But I do feel constrained with the remedies that are available in this particular instance.
So I guess to find a question in there to answer, I think I do think that staff has requested those types of analyses in the past. I can think of a couple examples where we have. I can think of a couple examples where we've said to an operator, this is not the best location, and you're going to, we're just not going to look at that. It's clear that there's alternatives available to you that you're not exercising. And so in those cases, I think we've been able to. I think we have stronger authority to do that when we are in a buffer zone location where we can look at the multi-well site production facility rule that says it should be as far as possible. Certainly the large urban mitigation area facility rules give us some strength of, so that we're not appearing arbitrary and capricious in our requests for an alternative site analysis on any given location. I think maybe clarifying when we can ask for that and when it's inappropriate, rather than it just being at staff's discretion. So, but I do feel that we have exercised that discretion and gotten pretty good information from operators in the past.
So is it fair to say then that under the current rules, if you have some discomfort with analysis has taken place, you can ask for more information and say, we think that you should have looked over here or should have looked there.
So Rule 303F allows us to ask for additional information as needed to evaluate a permit that's before us. And we have used that rule to ask for all manner of information on the Form 2A. It's, not something, it's maybe 5 to 10% of the applications that we're asking for additional information, or maybe closer to 5. It's not a lot of them. Most come in with what we need to evaluate the application.
Okay, just a moment. Okay, all right. Commissioner Hawkins, although I would encourage us at this point, we may want to take a break, but I was more considering that perhaps we've had a lot of discussion about this. When we want to get to a motion and make a decision about whether or not we want to have some type of a public hearing on this matter. But I'll welcome your comments, Commissioner Hawkins.
I'll make it very brief because I'm right there with you. I do think the rule provides ample opportunity for either local government or the staff to bring to us before a full commission hearing something they're not comfortable with. And I think that's should be our guiding rule in this instance, that neither the local government nor the staff has said we have some concerns that we think you as a commission need to address. So
thanks. For one, I'm going to see if I can find that document.
I can pass it over to you.
No, you gave me the doc number, so I'll test my ability to dig it up through OGC database search.
Excellent.
So, okay. While you were out, we suggested perhaps we could get to the point of, or are we to the point that we could entertain a motion as to where we want to go with this. We've had a fairly lengthy discussion, and I think the matter was in front of us is a request for a hearing, whether or not we want to have a public hearing. I believe it was a public hearing, Ms. Larson, on the BMCA pad Form 2A.
Yes, that was their request. You're correct.
Okay. That was Grand Valley Citizens Alliance. Through the public comment period, asked for a request for a hearing.
Can I ask just a point of clarification? Would that be at a regularly scheduled commission hearing, or would it be some separate hearing? Or we haven't gotten to that point?
We haven't gotten to that point yet. I think if we decide that we want to have one, then perhaps it could be, although it might be a challenge, I think we have one on the West Slope coming up this year.
There are 3 away hearings. Only one has been identified, and that is Boulder in April. The other 2 have yet to be identified, but we certainly could go to the West Slope.
I'm always holding out for Walden, Colorado, but that's probably a little too far away. So I guess we decide, and then we would, once that happens, then we do decide to do that, then we'd have to have a discussion. Do we want to have it separate, which we did for Adams County, or do we want to try to roll it into a regular hearing? And I think I'd probably want to have some input from staff on the challenge of trying to do an extra one.
Can I ask a question?
Absolutely, Commissioner Boygan.
Do I understand correctly that the 2A was approved, but there are Form 2s that are pending and have not been approved?
The Form 2A, the oil and gas location assessment, was approved on January 11th. The related Form 2s for all production wells and the injection well are still pending approval here at the commission. The reason they did not get approved with the Form 2A, at the time we were engaged in the final approval process, it was noted that the Form 2s were submitted prior to this commission changing the Piceance Basin spacing orders, and therefore they didn't meet the current Piceance Basin spacing orders and are being reviewed with the operator for compliance with that order.
What I'm getting at is, if we decide to have a hearing, does it stop everything? I mean, presumably there would be no work done on the site. If the Form 2s haven't been approved, obviously they couldn't drill anyway, but there might be some preliminary surface work that they would otherwise do on the site since they have their approval. So would we be entering an order temporarily suspending the approval or modifying or what? I'm just not clear on.
Mr. Chair.
Commissioner
I
Egger.
think this goes back to what I was saying too, because I think first we have to figure out why we would have the hearing. And I'm still unclear. I think a lot of what it would be is to give some of the public who feel like they weren't heard a chance to talk. And we got this letter and some other things, and staff has addressed all of those today. At least they may not have addressed it to satisfaction of everyone, but they've addressed how they viewed those comments and how they looked at these issues. And so what would we do at the end? It would be the public would have a chance to speak. Staff probably give the same presentation they gave today. I imagine Garfield County would be there to tell us why we shouldn't be changing any decisions that they've already made. And so what are we doing at the end? I still don't know. Is it just a hearing to let people be heard? But
Yeah, what would that change at this point? I think it gets back to what Commissioner Boygan said. If it's a hearing, because we believe that there's some space where folks haven't been heard, although, you know, when I look at that list, it looks to me as if they haven't had a chance to talk about this in more than one opportunity, then what else do you need to do? And I think Mr. Boygan says that we're essentially, if we're going to have that hearing, then we're basically going to have to shut down any further work on the pad. And now we're overruling the staff's decision. We're essentially taking a lot away from Garfield County's participation in the process, which is what we gave them in the rules. I'm really struggling with why we need to have the hearing.
It strikes me that we are debating the merits of a motion that hasn't been made. So in
Yes.
the absence of a motion being made, and perhaps we do a last call where anybody who wants to make a motion can make said motion. But
Then we'll debate it. That's a good point. Very well. Would someone like to make a motion? We're not going to make a motion. I guess we're not going to do anything. We might as well adjourn and go home. Commissioner Gibbs.
Sure, I'd like to make a motion to have a hearing on this issue.
And what's the issue?
Excuse me?
And what is the issue?
Well, we've been talking about this, allow public to come in, allow Ursula to look at, alternative siting rationale.
Which I think they've provided that already, have they not, Mr. Dronlow, the latter?
Yes, sir.
Okay, just a moment, please. Okay, all right. So he made a motion on the public hearing. Is there a second? It's made by Commissioner Gibbs. Mr. Hawkins.
For the purposes of letting us discuss the motion even a little bit, I'm going to second the motion.
Very well, that gets us to a point of discussion in the motion. So motion made by Commissioner Gibbs and seconded by Commissioner Hawkins to hold a hearing on the BMC APAD Form 2A. Discussion.
And
Commissioner.
so I go back to my question that I asked. We can hear all day, but what can we do? And I don't see a lot of I wouldn't get a lot of satisfaction if I was a member of the public and I spent a lot of money and effort to talk for no reason. What can we do about it? after they talk.
Very good question, Commissioner Ager, or sorry, Commissioner Overturf.
And I will say that I am in the same place. It is not clear to me that there is a clear remedy that we would order in this at the conclusion of this hearing.
Mr. Chair,
Yes,
to follow up,
Commissioner.
if the public needs to be heard, I can be for that. I want the public to feel like they're heard. I saw a lot of evidence that there was ample opportunity at the local level, but if my fellow commissioners can tell me there's value in that and not wasting everyone's effort, I don't want to shut people down from being heard. I just don't know that we can do anything about it after they're heard.
I'm struggling with that, particularly in looking at what Mr. Geronimo presented. Is that, where have they not had that opportunity to speak out more than once on this issue and bring a number of all these things forward? I have a real hard time saying that you had to be totally asleep at the switch to not be able to speak in several hearings that were held in a local venue.
And so that goes back to they did, but don't feel like the decision that was made was proper, and that we may overturn some of those decisions or be able to overturn them in the interest of public health and environment. Is that true? I asked the lawyers here.
Yeah,
Can we do that?
Yeah, that would be the potential outcome is would you overturn the decision on the 2A?
Right.
After the public hearing.
And we can do that, right?
Where's our attorney?
That's a big question. And I think that's something that would require a significant amount of discussion and thought, and probably an executive session before I gave an answer that considered all of the various parameters that would need to be considered. It's a discussion, I think, that requires nuance and a discussion of quite a few different areas. It is not just simply yep or no.
That's a really good answer.
Well, I appreciate that. And so I don't want to, I think we can offer an answer, but I don't think it's an answer that I can give a full, measured and considered answer to right now.
So to me, that means it comes down to, are we as a group dissatisfied, have enough questions in Mr. Geronimo's presentation today and the analysis that staff did to approve the 2A, to think that the public could come and change our minds?
I guess it's possible. One thing that occurred to me is when we undertook for this rulemaking, it was part to be able to provide local governments more opportunity to have input into the process, particularly for areas where there's a fair amount of urban development. I'm left with the concern that we're essentially, by doing this, we're backtracking to where we were before the rulemaking. And we're taking something away that we provided them with that opportunity. What generated the rulemaking and part of the governor's task force was that the local citizens don't have enough input and local government doesn't have enough input. So we said, okay, we'll make that work through this rulemaking by providing that more of an opportunity. Now we're saying, oh, well, let's take that away from them. I'm left with that. Now that may be incorrect because I see one commissioner shaking her head no, but that's where I'm left with this, is it tends to possibly take that away again.
Mr. Chair.
Yes, Commissioner Hawkins.
I think, that we put this rule in place to try to address concerns that the public, the local government, and industry had about, large scale developments near urban development, near a lot of neighborhoods. And it was a collaborative process. to provide as much input to local government and give them an opportunity to have their say on where the sites ought to be from their perspective. And if they're not happy, they can come to the commission and present to us why they're not happy and what they would propose. We've also given industry the opportunity that if they didn't like the outcome of the 2A process or the government process, they could come to us with a hearing and request something different. And I think even the staff, if the staff was uncomfortable with the analysis or some aspects of the development, they could come to the commission and request a hearing. And I think in the absence of those three parties coming to us and asking for the hearing, it indicates to me that all of those parties have been satisfied, that there's been enough technical analysis, there's been evaluation of various sites to satisfy the local governments. I don't see us having more expertise than local government or staff has in selecting a different site. So I don't see the value in calling for a hearing on this on our own. I'm not saying we wouldn't have the authority to do that if we felt that there was an issue that should be addressed. But it appears to me from the presentation today, there's been a lot of technical analysis from staff and local government looking at different sites. I don't think we're going to have anything that we can be more, better judge of this than what has already been judged. So I'm not, even though I supported or seconded the motion for this purpose of discussion, I don't think we really need to call a hearing on this matter in this instance.
This is Dan. I'm sorry.
Go ahead, Commissioner Gibbs.
Yeah, I move that I remove my motion to have a hearing moving forward. In general, I believe that, this is, you have 24 wells within 1,000 feet of homes. We've heard from many people that have concerns. I recognize that the local government, county commissioners have, done a more of a local analysis. But in general, I like it when people show up. I like it when we can hear from folks that like this, folks that don't. And that's, part of my reasoning why I just thought, having a hearing to just get all information out that we may have not heard before would be a positive. I have been able to, I did receive the email, so I've been able to look over the PowerPoint that you all have seen too. So that's very helpful as well. And it's hard calling in, so I can't hear everyone as well. But again, I'll just, move that I remove this motion at this time.
Maybe you could talk to your boss and he'll give you more time at the next hearing.
Mr. Chair.
Yes.
I need to,
Mr. Davenport.
just as a point of procedure, we need to follow the proper procedure under Robert's Rules of Orders. Commissioner Gibbs made a motion. It was seconded. Under the rules, it is now the property of the entire commission. And so the entire commission has an opportunity to object to that motion being withdrawn. So procedurally, you need to ask if any commissioner has an objection to that motion being withdrawn before it can be withdrawn.
Thank you. I was about to ask that. Do we only not as eloquent as that? I apologize. So Commissioner Gibbs is asked to withdraw the motion. Is there any objection amongst the commissioners to withdraw that motion? Hearing none, the motion is withdrawn, but thank you very much, Mr. Gibbs. Commissioner Jolly.
Thank you.
I think that was a very good discussion, and I think we've made a lot of progress. This was not going to go anywhere, I don't think. I know there's people that aren't happy with where the site is, but there aren't many sites that, if any, that could accommodate what they've worked out over there.
Okay.
I can think of sites right now I've certainly got concerns about in the future. that that are coming up that I think this process is going to be very helpful. So,
Okay.
Chair, I have one more comment too.
Yes, Commissioner Ager.
I would say that I appreciate Commissioner Overturf requesting this discussion today, and this presentation is incredibly helpful and allows us to get a little deeper into this than I think we have in the past. And I expect we're going to be doing this more often with some of these locations that are contested or talked about a lot. And so I think we have to be ready to probably squeeze these into our hearings so that we can make better decisions about how to move forward in this instance.
Very well. Yeah, we've never not provided that opportunity to hear folks come and talk to us. So, Mr. Overturf.
Yes, just in reaction to that and in having conducted this entire discussion, I wanted to just come back to what to me was the most important to communicate, which was that wanting to make sure that staff feels like it has the ability to ask for the consideration of any alternative site that either it or any other party, any other commenter identifies as part of this process. That if a public commenter brings forward an alternative site, that if staff believes that alternative has merit, I truly do hope that staff feels that it has the ability to ask for an evaluation to understand why or why not that alternative site is appropriate. And so as these conversations are going to continue, I have no doubt this is not the last controversial 2A application that staff will be dealing with. And so I hope that there continues to be, and perhaps there is an expanded, robust alternative site analysis going forward.
Commissioners, if there are no other motions that we wish to make at this point in time, we can conclude this discussion. Because we've made a motion that's been withdrawn, been instructed by our attorney that that's a path that we can take. We don't have to have a motion to conclude this discussion. Is that acceptable? Very well. Thank you all very much. Thank you, Commissioner Gibbs, for the effort that you went under to listen in, because it's not easy.
Thank you. I'll get off now. Thanks.
All right. Thank you very much. I think at this point, this concludes our hearing other than a
Motion to adjourn?
yes, a motion to adjourn.
So moved.
A motion has been made by Commissioner Boygan to adjourn, seconded by
Second.
Commissioner Ager. All in favor, say aye. Aye. We are adjourned. Thank you again.